I have considered most of your contentions and relevant of the judgment cited. I have not considered all judgments cited. I need not also. Otherwise, I have to write the thesis instead of writing the judgment. So relevant judgments I have considered. I have also considered what was held out in the advertisement. Then Desh Prakash, which Mr. Swain had quoted, and Vinod Kumar, which panel counsel had quoted. Then Vedanga, which you had quoted, that I have considered. Then MP Service Commission versus Navneet Kumar, you incidentally quoted, that I have considered. Then Quinn versus Latham, I have quoted my own. And in my wisdom coupled with abundant ignorance, I have written this judgment. I have allowed the petition. And the operative portion of the order is this. In the above circumstances, these petitions are allowed with the following directions. The selection process to the 711 posts of Hindi teachers, as has been done hitherto, is quashed, retaining its stays anterior to written main examination. The Commission shall hold preliminary examination in terms of the recruitment advertisement so far the posts of Hindi teachers are concerned. The Commission shall also provide bilingual facility as has been held out to the public in terms of the recruitment advertisement. Lastly, the above exercise shall be accomplished within a period of 3 months, reckoned from the costs. I wanted to levy costs deeply both on the government and the Commission, but some reluctance I have shown so that next time they will not do that foolish things. Everything has to have given the time of exercise because the students will suffer. Students should not suffer. Candidates also should not suffer. Endlessly going on like this. Therefore, the entire exercise is made time bound. Yes. Thank you. I learned so much from both sides. Yeah.
Item 2.
My lord,
yes.
Rective is not 7 tank.
9925 order you are running to?
No. It is already described on 27.
You want accommodation? Time we need?
Time, sir.
Time. Call this matter after 2 weeks at the request of the Legislative Council. You are for the petitioner?
Yes.
Petitioner. Yes.
Item 3.
Item 3, last week this matter came up, and Lord, with reference to the order dated 7/4/1998, I pointed out that order passed by this Honorable Court. My Lord also wanted to know what happened thereafter. In fact, thereafter another order was passed by this Honorable Court, that is order number 16, dated 5/11/1998. There certain developments have been reflected in the order. But thereafter, what happened, my Lord? Despite my all efforts, I could not contact the petitioner.
But 90,
they have not damn.
May I suggest?
Yes.
5/11, there is a order. So, my lord, as per the instruction, the then Government Council has submitted that let them file the application in pro forma form specified under the OGLS Act, my lord. To the authority, that will be considered. Even in that line, it can be disposed of because no instruction is there. In the meantime, years has been lapsed.
Why 11?
1998. 16, order number 16. 16.
Can you pass that order?
But I don't have at the moment, but whatever I have gathered, there is a direction.
Give out 5. So you agree that
Yes, yes, yes.
liberty,
Yes.
you at least file a memo.
Yes,
So that I will dispose of that matter in terms of
I will file. I will file in course of the day. Immediately, I am filing.
You just file it. Password. Just show me.
Yeah.
I then.
Yes, Lord. This I'm just placing, Lord. This matter was not in the list, but is being taken up on being mentioned. Learned additional government advocate on the basis of instruction received from the collector submits that if the petitioner makes an application to the in the prescribed form under the Orissa Government Land Settlement Act, government land now available in Unit X, Dungarpali, can be settled with him provided he is agreeable to pay the premium of the land of the prevailing market rate. Sri Mahapatra, Learned Counsel for the petitioner, says that the petitioner may require so much of land, which was in fact in his unauthorized occupation, decimals of land, for the purpose of construction of the said. The learned additional government advocate will take instruction as to what the premium for the said land. What would be the premium for the said land? He will also disclose the basis on which it is stated that the petitioner is not a landless person and his income exceeds 11,000. Put up this matter thereafter, Lord.
So in terms of this order, can I write the dispose of the matter?
Yes.
But just to give one memo saying,
Yes.
in terms of order dated 5/11/1998,
Yes, Lord.
matter may be disposed of.
Disposed of. I'm right.
But the petition prayer reads as that. First, this is a very old petition. First, learned counsel appearing for the petitioner draws attention of the court to coordinate bench order date 5/11/2008, which reads as
98.
5/11/98, which reads as next paragraph. Learned counsel for the petitioner submits, and learned AG appearing for the office does not much object that the substance of the above order can be the substratum for disposal of this petition, reserving liberty to the petitioner to make appropriate application for the grant of land in a normative basis. First, this is a happy development happening in the old matter. First, next one, in the above circumstances and with the above observations, petition is disposed. OGC is disposed of. Yes, thank you. Item 4, one line memo to this effect is filed by counsel for the petition. Yes.
Item 4. This is a old case in 2004.
Yes.
The problem was the council who was appearing last time on 26/9/2025. Because he was appearing for the state in that particular case, he had to retire from that case. So we are appearing today. And in compliance with the lordship's order dated 26/9/2025, I found from the ROC. I am filing the legit. The lordship wanted that legit. I am filing the certified copy of the legit. Because that last order, the last line, you will see that.
Go to that one.
26/9, that's all. Lordship has said on counsel for the petitioner to produce the list deed by the next date. Non-production may
This is certified copy.
is certified.
Original is with you.
Original, it has to produce the highest suit out of which the matter was carried to them.
But how to read this? It is impossible for me to read this.
I'll make a translation. I'm extremely sorry. I don't know, but I'll make a translation. Also give some breathing time so that my non-friend has also no brief. I will prepare a brief and I'll give to my non-friend also.
You file one English.
Yes, certainly. I'll do it. And my non-friend is also appearing along with me for some of the petitioners.
A coordinate bench of this court with order dated 26/9/2025 had said as first. Next paragraph. In terms of that, a memo seeking leave of the court to produce the certified copy of the document in question was moved this day. First off, accompanied by the conveyance in question. First, The script in the conveyance is not that legible. First off, but let's senior advocate on instructions of the instructing counsel submits that they would make available a typographed copy of the conveyance on the next date of hearing if short accommodation is given. First off, other side does not have.
No, I am not other side.
He also along with.
There are batch of bits.
You are on the other side.
Yes, that's me.
Let them give the typographic
Copy also.
after serving copy to you. The other side does not have objection to this proposal, provided that the copies to be filed shall be served on him in advance. First one. Next paragraph. In the above circumstances, call this matter in the third week of November. Third paragraph.
Item 5.
Have to be all.
I will taken up after launch. Conducting counsel is out of session. He will come after lunch.
After lunch?
Yes.
After lunch, you will also be sitting in division.
After lunch, we have another division.
Yes.
My lord, what happened in this case, the velocity amount of the petitioner has been withholding by the
In the second week of November.
say,
Call the second week of November. It's a request of.
Item 6.
Here the matter relating to grant of professor scale of pay to the retired petitioner, keeping in view the coordinate bench judgment annexure 7. And even though similar cases will also be disposed of, directing to government to consider. And in the present case also, the petitioner has also made a grievance annexure 8. But in the meantime, they have already rejected similar cases and they have also filed several petitions by challenging that rejection.
Along with that,
Yes, we also already issued notice in the way.
Go to cost taker. Mr. Lenka for 1. Emergency notice to 1 and 4. 1, 3, 1, 2 and 4.
State is for 1, 2 and 4.
1, 2 and 4.
3 to notice.
Emergency notice 2, 3. All along with WP numbers.
All already given.
Next.
Item 7.
May I please, Lordship?
Yes.
Here, my lord, petitioner, while the present case, under the SCST Act, should be asked, my lord. And the petitioner's father, as well as the uncle, both are.
Can I request you to speak through the mic?
My lord. Petitioner as well as their family members are attacked by the poor villagers of the upper caste, and due to that caste attack, the petitioner's father as well as the uncle died. And against that, there is a criminal proceeding as well as the petitioners.
You take notice, it appears to be largely covered by the Bombay judgment.
State is only for 4, 5, 6.
4, 5, 6.
Then Union of India, 1, 2, 3.
Learned ASC is requested to accept notice for 1.
1, 2, 3, Union
No,
of
2
India.
and 3, they have different commissions.
4, 5, 6 is the
State.
state,
4, 5, 6.
And the orders?
Notice to 2 and 3.
order to be executed of 4, 5, 6.
That
The last order, the Hon'Ble Court.
Union notice to go 1, 2, 3.
There no need to for 1, 2, 3, my lord. 1, 2, 3. But 4, 5, 6, they have to comply that because there is an order of this Hon'Ble Court.
But you have made them parties, no time to go. We do not know what they will say.
I have already served the copy to the Union of India.
Yes.
No, they have served one copy as a advance copy.
They have a panel
If
council.
we don't have any rule, then our name may be deleted.
1 ASC. 4, 5, 6 Lenka. Yes. Post immediately after the weeks. Yes.
Item 8.
Date may be fixed.
Like, will come on. The service has to take this. Yes.
Okay.
Item 8.
Purely private issue, madam.
Huh? Marriage
Private
declaration.
marriage, yes. Marriage before the, through notary affidavit, is a purely private issue.
That's all right. None appears for petitioner. calling third week of November to enable counsel for the parties to come and argue. Yes. Item 9.
May I please ask? The petitioner is a Hindi teacher, but his services were terminated on 9/11/2010. He preferred an appeal before the joint director. He succeeded in that appeal.
Monthly salary has to be paid from 5 to 25.
5 to 2025. Here what has happened, my lord, the person who was appointed in my termination vacancy, he challenged the order of the joint director by filing a writ petition before this honorable court. That is WPC number 11309 of 2018. And that was also dismissed. I have annexed a copy of that order. Annexure 4. And despite that, and
Anyway, you have given a representation.
well, representation will not do. Well, now the district
Duties.
well, yes, your lordship may issue.
Notice be issued because the aberments in para 11 that in the meantime is put under suspension.
No, not suspension. Suspension is
This is the aberments. And another writ application has also been filed.
yes. Your lordship may issue notice.
Mr. Mohanty, DG accepts, is requested to accept notice for 1, 2, 3. Emergent notice to 4.
Yes.
Yes.
Post materialize in a narrow compass. Post in the third week of November.
Yes.
If service is effective.
Yes, sir.
Item 10.
Your Lordship, I am appearing on behalf of the petitioner.
Yeah.
Petitioner is a pregnant working lady who was working as a front desk manager in Hotel Hindustan International.
Yeah.
And she was denied to get the maternity benefit from the company.
It's a statutory duty.
Yes, Your Lordship.
Take notice then.
Yes, Your Lordship. Obliged.
Emergent notice. Enable within 6 weeks of this. Item 11.
May I please, the lord?
Yes.
My lord, in the prayer portion, there is a typographical mistake. Instead of annexure 8, it will be annexure 9, man.
Annexure 9.
Yes, ma'am.
You repair it and petitioner is counsel for the petitioner on oral request is permitted to rectify the prayer column. Yes.
Sir, my lord, the annexure 9 is pending before the opposite party number 3. And that annexure 9 has been filed. Your lords will get at page 46. What's on to direction of the State Education Tribunal.
They are sought for a withdrawal of the order dated 21/10/22.
Yes.
That representation to be considered.
Yes, ma'am.
Short grievance of the petitioner is reflected in the short prayer in the petition. First of all, counsel for the petitioner draws attention of the court to the representation dated 16/4/2022, the copy whereof avails at annexure 9. Right. She has, he or she has sought for rescinding of order number 11341 dated 21/10/2022. 22. First of all, counsel for the petitioner submits that if a direction is considered for its is issued for consideration of the subject representation, is client to be satisfied. First of all. Mr. Mohanty, you have any objection?
No.
Mr. Mohanty, learned AG on request appearing for the OPs, very fairly submits that he would instruct the OP number 3, OP number 3 to take a call on the subject representation in accordance with law if all contentions are kept open and a reasonable period is prescribed. First of all, this is appreciable. Next paragraph, 8 weeks. Open to solution. No cost. Next. Item 12.
So petitioner is a physically handicapped person and also your third position in the national Paralympic
to group 3.
Yes, madam. But the appointment has not been given. Your Lordship may reject some. Your Lordship is directed to consider my representation.
That is rejected.
Rejected.
24.
Yes, 24 my
notice.
only take up.
Well, the
Annexure 7 is there, so far the rejection is concerned.
they have to file on that.
Notice.
Chairman, the
Month is requesting to
I can only receive for one.
Only one.
Number
2, 3, 4.
2, 3, 4 notice, ma'am.
emergent notice to the rest. Yes. It's a matter relation to person with disability, call this matter in the last week of November 2025.
This is an athletic quota.
That's all.
These are Paralympic.
It's also PWD.
Yes.
Yes. Last week of November. Yes.
Yeah, annexure 1, page 30, kindly have a glance, my lord, page 30. Here, my lord, I am a retired reader. Retired from service, my lord, 30/11/2020, and getting, my lord, provisional pension. Now, my lord, a letter was issued that the government has decided.
Granting aid is withdrawn.
So they have decided to withdraw.
That's all.
Now, kindly see the provision they have indicated. Section 7D of OE Act and paragraph 21 of Non-Government College Orders 19.
That is not
21.
quite
That was a different.
You take.
I will take notice. Here the fact remains, for a particular period, they have been elected as a sarpanch. For that, exactly.
That was my lord in the initial stage. After that, I joined and completed my tenure and retired from 2020. my lord.
Issue emergency. Go to the cost taking. Learned AGM is notice, requested WhatsApp notice for all respondents.
My lord.
Or higher secondary school, that 6 also.
No, six my lord has to go notice. Notice has to.
Notice has to go.
Next.
Only there is an interim application. my lord.
What interim application?
I have been getting now at least provisional pension from 2020. In the event that this will be carried out, I will not be getting provisional pension.
It has to be paid. Otherwise, also this order appears to be answered.
For that gray area, all these things happen.
An application is moved seeking interim protection. It is supported by an affidavit. Counsel for the petitioner submits that his client is a retired person and is in the evening of life. First one. He further submits that if pursuant to impugned order dated 19/2025, Annex 1, if payment of pension is stopped, he will not have anything to hold his body and soul together. First one. There is an arguable case for granting the interim protection. In the above circumstances, the subject application having been favored, impugned order is stayed. Yes.
Item 14. Yes, sir. Now, compliance of the lawsuits. Judgment dated 8/25. And they have received it.
25.
Yes,
What was the order?
the Lordship directed kindly from to page
Page 16.
16. In the above circumstances, the writ petition succeeds in part.
Request.
The
Item as follows: accommodate petitioner in one of the vacancies in post. Why, brother? Why are you not accommodating?
I will take instruction.
Appeal against this order.
I will take instruction.
Huh?
I will take instruction.
Whether notice has to go through police because it's a contempt.
No, I will take instruction.
No, what are the rules in your state? In contempt matters, whether notice has to go through police or it
No, Malad, notice it will be issued and we will file the show cause. But I will take instruction here, Malad.
But
Last time it-
if that order is not complied, I will summon the concerned person.
No, Malad, I will take instruction. But it's a 88/2025. Last time it is coming, Lord. I will take instruction.
That is the Mr. Hon'Ble volunteers to accept notice for the OPs. Which OP?
one Lord.
No, all this whole.
No, in contempt matter, whether AG appears for the private parties. There is a judgment of the
Nahin.
court which says private parties cannot be represented.
Strictly speaking, it cannot be.
No, strictly
But, but
issue police notice to the
Malad, instruction, Malad, for the first chance, Malad, first time it is being listed.
Therefore, I'm issuing police notice. They want to engage, you engage. Let them engage. Let police go to their house.
May I pray for it? I will come back and
No.
with the instruction.
Issue emergent police notice to the OPs. The OPs to be present before the court on the next date of hearing. That is 2011-2020. Yes. However, it is open to them to move application for exemption if grounds to exist. Just like police should go to the government. Only then works will happen. Otherwise, nobody cares court's order. Yes. You tell them something bad will happen on the next date of hearing.
For that purpose, I will search for the instruction and come back to your lordship to apprise.
There is some reason why I am doing this. Like nobody has respect for the court. Yes. Item 15.
My lord, item 15, can you take it passed over, my lord?
Pass over.
Yeah.
What is this matter about?
I looked at the slum dwellers.
My lord,
It was fixed to
Today.
That CDA, Cuttack Development Authority,
Yeah.
that matters some of the persons.
Pass over. Yeah, after lunch?
after one.
mild.
After lunch, there is my lord, division bench.
Or you come
Before lunch.
Yes.
Before lunch.
Mr. Palit, who is the senior advocate, he is conducting a case in another court, so he told me.
Let it be at 12 o'clock.
There is only one matter, perhaps in the afternoon.
Yes.
Just come later. After 5 minutes.
Five matters, my lord.
But take a chance, let us see. Oh. Item 17.
16.
16. Withdrawn. Yes.
Affidavit.
You filed affidavit. Let us see that Mr. Parija and Mukherjee, have you seen the affidavit?
I have been told, I haven't seen it.
Give copy.
It's sacrilegious.
Yes.
I'll provide you. I have only one copy.
Just give a copy. Just sit and give it.
No, that's all right, sir. We'll share that.
Why? We'll give. We have Xerox machine here. It is useful for persons like you. Yeah. Get Xerox of that. What was the order, sir, on that day? 24/9/2025. Personal presence is dismissed. Before that, what was the order?
Dismiss for the day, Mills.
Yes.
Nineteenth September.
This court ought not to have passed the order of the time, especially granting different additional projects in the matter given for Hon'Ble Justice. We who also claims social it states in the court of hearing today that this was brought to mind in the first day of the petition was heard from the first the above being said that gross criminal contempt of this person therefore action will be initiated in the petition. But it shows that the previous allegations are made against the net watching the judge of this court and on that ground passport of the outcome was sought for from this court to another. The party and draws the attention of the court to such a to express the expensive power to deal with criminal contempt cases of the world. This is India was out of hand. This court has so many the board of consultation of the district of mostly parties conditional apology to the government what it is not the what the regime where senior show that you might have also Yes, where is your affidavit?
My lord, is there.
Give.
Specifically see paragraphs 2, 4 and 5. 4, 5 and 6. We have to.
Yes.
Lord, this is no apology. Great respect. We fixed with so many conditions.
And what is it that he is regretting? That also is few sentences.
Your Lordship may see paragraph 4 of your Lordship's order. Last but one paragraph, he repeatedly submits. May Lordship have that line, Lord? In your Lordship's last order.
Yes.
Your Lordships have said he repeatedly submits that he would file an affidavit tendering unconditional approval and also withdraw all allegations levying on the manager. So I don't see anything of that kind in this affidavit.
This is not in tune with Mr. Mahapatra. This is not in tune with the order. This affidavit does not reflect the fit and substance of this order, which I made very after giving full opportunity to you, and I have recorded whatever you have said. It's available online also.
Yes, my lord.
But you have gone to push Akhad after putting lot of oil on his body. What kind of affidavit? If I have done this one, if that is done, some of things are not. You want to draft them in another form. It should be one line apology. I voluntarily offer my unconditional apology to the court and to the judge concerned in terms of this order, and hereafter I shall not do such things. But you have made all this. This does not satisfy the court. It does not satisfy.
My lord, I will file another
It will
affidavit.
go on like this one. You come at 2:30. Bring another affidavit.
Okay, my lord. I'll do that. I'll do
Mr.
that.
Parija?
Yes, ma'am.
Let him come at
Yes, sir.
2 o'clock.
No.
My lord, I will file one sentence. I will file. I don't have anything.
The things I tell you, this is the judiciary is the only, kindly listen to me. Judiciary is the last ray of hope for the countrymen. Really. Judiciary, I am not saying judges. Judiciary includes bar and the bench. If you are not happy with the orders of the court, there are many ways and means to work out your redressal. But making allegation against such a good judge of this court, he may not be Lord Denning in your view, perhaps in the views of many, but he is a very learned and honorable judge of this court. I am making this statement after reading his judgments. I read his judgments because I had abundant time. I have no work other than reading the party. So your stand does not appear to be appreciable. I will say only this much. And you have brought, you other day you remained absent, you said puja. Very well, you have tried to do puja. We also do that. Anyway, that I can understand. But you have drafted this itself smacks of lack of bona fide.
My lord, with clean hands I have drafted, and it is my intention not to hurt anyone. I made unconditional apology, my lord.
Where is have you said unconditional apology?
Yes, my lord.
You have said all these things above. Thereafter, you are saying what the unconditional apology would be. Any standard book on law of contempt would give you one or two the instances. How unconditional? Read G.L. Gauba versus so and so.
My lord, I will read, my lord. But this is, for me, I come with clean hands and I do not want to hurt anyone. And I made the unconditional apology, my lord.
Let us read the
My lord, last line I'm reading.
last line. Everything has to be read. Only favorable to you is not sufficient.
I said, I regret for such sentences made in the pleading.
See, in the light of what you are regretting, see how it is done. From the core of my heart, I do express that few sentences in question of the WPC should have been worded the fact differently than in the present form. You want to retain them, but you want to change the frock. You want to change the frill. It should remain as it is. That is how it is. This will not satisfy. Anyway, I am not agreeable with this proposal. I am not going to give, because you don't appear to be a scrupulous litigant going by the stand you have taken in the writ petition. And I have given abundant opportunity to you. You have not done anything. I feel it is a fit case for being placed at the hands of Honorable Chief Justice for taking appropriate action under the contempt law. I'll send it to this.
My lord, I do not have any bad feelings with anyone. I tendered unconditional.
Those who have been heard, for them this will not be a solace.
May I just add one thing?
Yes.
The fact that there is regret is further borne out from another IA which he has simultaneously filed. That is IA number 18345 of 2025.
Give that.
Your Lordship, may kindly see that application.
Give that.
Lord, from browbeating the court, now it has come to browbeating me personally. Making allegations of what kind of money I have earned as AG, what I have money I bought later on, what kind of, enrollment certificate. I mean, this can't go on in this court. We are officers of court, assisting your lordships.
But I read somewhere, a bad certificate by a bad man is a good certificate by a good man. Yes. Which is that affidavit?
IA 18345 of 2025.
This is filed on 4th of October.
Yes.
And I think the prayer is I should be also impeded as a party in this case.
Baggage.
Luggage. Luggage. Lord, we are in your lordship's hands. We can't be browbeaten like these currents. The unscrupulous litigants. In great respect.
My lord is not part of. I said with a heavy heart that every person should come with clean hands, my lord. And I have lots of respect to bar and the honorable judiciary. It is core of I do perform my constitutional duty under Article 51F of the Indian Constitution. And it's particularly mentioned Rule 47 and Rule 48 of the Bar Council rules that advocate cannot be permitted to do business as managing director. My senior, Mr. Fariza, is a managing director of a company.
Wait, Mister, do not take name. Because everybody will be, you are painting as if...
I respect...
This is member of the bar.
Yes, ma'am.
Don't take name.
Yes.
You just read Mr. X, etc. Because the entire society will be looking.
Yes, my lord.
Seeing this one. This is too much.
Enough.
This is too much.
My lord.
What was the case before us? We never asked for horoscope of Mr. Parija, Mukherjee, etc. This was a matter whether the wild allegations which you had made against the judge are justifiable, or some action should be taken, or you should be pardoned for that, if at all your apology is tendered. Why all this? You want to put tomorrow, you will ask all the particulars of another judge and you will web host it and you will say, no, all that is available, I have web hosted that.
My lord,
not the law.
My lord, I may be given 2 minutes to share my feelings, my lord.
I'll give you 3.
My lord.
Not feelings. This is not a confession box in the church. You can argue.
Yes, my lord. My lord, once the matter.
Very well. Why you have filed all this?
Yes, I'm sharing I am submitting, my lord. My lord, this matter arised out of WPC which I have been filed, and this has been dismissed and withdrawn. But after this withdrawal of this petition, an I is filed by a stranger who is not a party to the petition, and the Supreme Court held in Subramaniam Swamy versus Election Commission of India, 2013, 10 SCC 120. It is well settled that persons seeking intervention in pleading matter must be assured direct and substantial interest in the subject matter of the litigation. And second, Jaipur Vidyut Vitan Nigam versus and another Adani Power Limited is said court has become Fox's officio and doesn't retain jurisdiction to enter an application after appeal was disposed of. This case was already disposed of, and the intervention petition is filed.
Kindly, see what was. Kindly come to your affidavit. What is this? You want to auction the reputation of people? Very important members of the bar. Kindly come to your affidavit now. Don't read the name, but just read the content. What is this you are doing? And insulting an advocate is a contempt of court. Insulting an advocate in the performance of his duty in the court hall is a contempt of court. And if the judge insults him, judge commits the contempt of court. That is the law. It is contempt of not judge. It is contempt of court because Mr. Parija, Mr. Mukherjee and rest of the advocates who are here, they are part of the institution. They are all tall figures who have grown with lot of toil. What is this you are saying? Kindly see. What is happening, Mr. Parija, in this court? What is this happening? That you are chairman of ACC, Associated Cement Companies. Being this, you are saying. Well, how it is concerned with you? What is the subject matter? You are wasting the time of the court and you are damaging the reputation of people associated with the judiciary. Therefore, you are damaging the reputation of the judiciary. Already people are speaking very ill of judges and lawyers with some amount of justification, it may be, arguably. And you want to denigrate the lawyers, judges, everybody.
It is not my intention that everyone's. This is the court of justice, my lord, and everyone should come with the clean hands. A person who stands as a senior advocate, he should maintain ethical fiber, my lord.
What ethical fiber he should maintain?
Yes, my lord.
To resign and produce a copy of the resignation letter with you. Who are you? Are you ROC? Registrar of companies.
My lord, the matter, your lordship had posted the matter for acceptance of his apology.
Affidavit form.
Affidavit form. My lord, that is not coming forth. What has come forth is to be rejected outright. And the very fact that this for so-called apology is coupled with this application shows in fact that there is no apology worth the name. He just wants to browbeat everybody who comes and stands in opposition to his intent.
This is rule of law. And we should just follow the rule of law. This is rule of law. So may I read, my lord, the High Court to Orissa Designation Senior Advocate Rule 19.
This case related to your contempt of court. Therefore, we had given you an opportunity to tender unconditional apology, and everything was held, proceedings were held online, order was passed. It is not your case that my order does not reflect the true position of law. You were given an opportunity to offer unconditional apology in terms of this order because you had undertaken to file one in the form of affidavit. You are expanding it in such a way that conduct itself amounts to contempt. Because you are wasting the time of the court.
My lord, if the functioning under the constitution, performing under the constitution 51A, and I feel, and it's my firm belief that I do not make any contempt because I perform my constitutional duty to bringing your lordship's knowledge, notice that what is happening here.
Here means in this court.
Yes, my lord. Yes.
My lord, that ends the entire debate, my lord. He says that he does not have any regret. He has not done contempt of court. So your lordship may proceed to in the manner that your lordship had already done. And there is no point in holding the judicial time to ransom at the instance of by such frivolous litigants.
This is not frivolous. This is constitutional duty to inform the honorable court that what persons in the rule of law in this country. A person is not advocate, is not entitled to the business. And being an advocate general, he has taken 23 crores and 48 banks and 14 accounts.
How we are?
Item 18.
Item 18, my lord, 18 password. 18 password? Yes. Next.
Item 19.
Simple prayer is the petition is my lords to publish the result and supply me the mark sheet. The case of the petition is my lords. Petition is an MCA student. It's a master in computer application. And admitting the student, admitting the my lords in the 3 years course. MCA is a 3 years course, my lords. And having 6 semesters, my lords. And first
See, number 4, 2 and 4 to publish the result.
Publish the
result of which examination?
MCA.
MCA.
Master in
This is beyond 6 years.
Please, your lordship. This is a case of beyond 6 years. And the regulation says that in case the student clears all the papers, in that event only his mark sheet will be published. Otherwise not. That's the regulation says. Your lordships, may I bring to your lordships notice a similar matter has been disposed of by your lordships. This court, your lordship. Where the petitioner approached
a copy of that judgment.
Give me a copy.
Yes, give copy and get Xerox and we have to keep one Xerox man here.
My apology, lords. I should have brought another.
You don't want to, you will not publish the result, I can understand. But supply the mark sheet.
I was allowed that.
Give them the marks. No, I'm just going by one. I will not close it at I'll hear your submission.
Please, lords.
Yes. During what period he was there as the student?
Your lordship, from 2010-11 academic session till 2015 and 16 academic session, including the grace period of 3 years, your lordship. Within these 6 years, he was to clear his examination.
Which is that rule?
Your lordship, the academic, I will. Understood. Your lordship may come to paragraph, page number 13, your lordship, annexer A1 of my counter affidavit.
It was counter affidavit.
Please, your lordship.
So rule position you have put there.
Pardon, your lordship.
Duration of curriculum.
Please, your lordship.
Duration. Creation of the program shall be governed by the regulations as it is that may change from time to time as further. One point three.
Please, Your Lordship. Please, Your Lordship.
Which, if they do not do these things within the prescribed period, result shall not be published. Where is that?
This was mentioned in the admit card, Your Lordship. In the admit card, it was mentioned that in case the student fails to pass in all the subjects, all the semesters, his results will be automatically blocked. It cannot be published. It's only
Should he not know that he has failed?
This also that.
He should know in which subjects he has failed, so that he can go for improvement.
Because that period has already gone.
No, that's all right.
Please.
He may not be in your campus, but he can address his own problem by taking tuition, etc. He may not appear for the examination. Suppose I am a judge. I do not know good the theoretical physics. I do not know. I may take tuition from good theoretical physicists for my satisfaction. But I should know in which subject I am weak.
Admit card was issued, my lords. I appeared the examination. Thereafter, they said that result will not be published.
Thereafter?
Thereafter, they said result will not be published. Admit card, my lords, they have issued the admit card.
In the admit card, you have said?
Yes.
Please, where is that? The result shall not be published?
It's in the rate witnesses.
Admit card, my lords, annexure 2, my lords.
No, read. What is that? Where it is said that if you do not complete all the papers, pass in all the papers, your result may be fail or pass. I will not publish the result itself is too much.
Your Lordship, may come to page number 19 of the rate petition.
19?
19. Why, yes, please. 19 of rate petition.
Is not to allow the students to appear for examination in any paper in which the candidate does not meet the requisite attendance, so and so.
The second note,
the result will be published subject to clearance of all academic regulations. Regulations.
Please, Your Lordship.
What about, he has written the examination.
Please, Your Lordship.
He is entitled to know the result. He might have failed.
Now, Your Lordship, background is 2 more rate petitions were filed. Prior to this one, this is the 3rd round of litigation. Prior to this, 2 more rate petitions were. The first one was, Your Lordship, we kindly come to.
Are they pending?
No, Your Lordship.
They are disposed of.
Please, Your Lordship.
No, I am in this one. What I am asking you is,
please, Your Lordship.
He has appeared for the examination.
Please, Your Lordship.
He wants to know that he has failed.
Please, Your Lordship.
Even that you will not let him know. Failure also.
Publishing, Your Lordship, that has been, Your Lordship, prohibited. Because
publishing is the rule. You have put it just one line in your admit card. Please. If you find a route, write in the admit card. Whoever writes the examination has to leave all his clothes in the examination hall itself. Will it be valid? Where is the authority for saying that in the admit card? Admit card is not an instrument of law. Permission to gain entry to the hall and to write the examination.
Listen,
I am asking you, which regulation authorizes you to withhold the result eternally? It is withholding the result eternally. He is entitled to know. He may not be permitted to appear. Result he wants to know. How can you prevent it?
I will answer Your Lordship's query. I may take instruction with this respect only.
Oh, no. That's the only case.
Lordship, with regard to this aspect only, I will take instruction. Any sort that Your Lordship may dispose of the matter.
All on. 11.
It's posted tomorrow.
11.
Oblige, Your Lordship. I will clarify that position, Your Lordship.
Yes. There is one law relating to education by B.M. Baliga, Professor B.M. Baliga. He has referred to one judgment. Just try to bring that in your favor. There may be judgments in your favor also. I do not know, but just do it there.
Louder, Your Lordship.
Okay.
End of things.
Item 20.
Permitted to withdraw, madam.
Has been transferred. I think my blood is appearing.
Permitted to withdraw, madam.
You want to withdraw?
Madam.
No. This Court of Appeals, I will be doing, not just similar order. Yeah. Item 21.
Item 21, Your Lordship. Your Lordship, the petitioner is a childcare institution that has been existing since 1982 and has been continuously receiving grant in aid till 2017 to 18. Thereafter, the grant in aid was halted in an arbitrary manner without any notice to the petitioner institution. Your Lordship, thereafter, the petitioner approached this Honorable Court and in a litigation prior to this one, this Honorable Court had also directed that the grant in aid may be, a decision regarding the grant in aid may be made on the basis of recommendation. Thereafter,
What did you say, brother?
My Lord's direction, earlier the petition, my Lord, the opposite party number 1, government, my Lord, that is Annex 1.
Mukherjee is appearing in this matter.
Yes,
My Lord, the Annex 1, Lordship can have a large, my Lord, to page 23.
What is the case, Mr. Mukherjee? Why they have stopped the granting aid?
Well, it's, the petitioner is one of the oldest childcare institutes of the state. And when granting aid started in 1982, they were one of the first recipients of granting aid. From 1982, continuous up to 2017, 2018, they were receiving granting aid. In 2018, there was a particular officer who had some problems with us. And she did not recommend for the year 2018 for giving granting aid. Now, that is not the procedure in which is required. It is required to be done because under Section 41 of the Juvenile Protection Act, Juvenile Justice Act, certain regulations are formed. The regulation says that if you want to stop granting aid, you can suspend, and within a specified time, that 30 days, you have to give a show cause notice. And that show cause notice has to be adjudicated, and thereafter by an order you can suspend, you can stop the granting aid. Nothing of that sort has happened.
No, any opportunity of hearing got given?
Nothing was.
The time bound. Every year it is being given.
Every year it was to be given.
But where is the right of renewal as such?
That the scheme itself says that old existing CCIs and new CCIs. Existing CCIs are treated in a particular manner. They are recommended by the state, the district, initially by the district level, because all these CCIs are inspected every month by the district judge. The district judge submits a report. Then there is a child protection officer and a committee headed by the collector. They submit a report. And they recommend that the CCI, that this is the requirement of the institute. And accordingly, a proposal is put forth by the state before the central committee, because there is a matching grant of 60-40 or something of that sort.
Center state.
Center, Mission Vatsalya is the program. And there are two categories of institutes which are given. One is existing, one is new. As far as the existing is concerned, the center has never interfered. In fact, the funds that come from the center remain unutilized at the end of the state. That is what the records say. Now, this particular mischief which was perpetrated against the petitioner in 2018, thereafter, what they did was, they did not recommend us. And that is why we came up before your lordships. Annexure 1 was an order passed, which was challenged in the present petition. Now, when the matter was taken up for hearing, the state government conceded before this honorable court that Annexure 1 is an illegal order. It cannot be sustained. So this honorable court, by an order, permitted them to re-adjudicate the matter.
It was set aside?
Yes, it was set aside and re-adjudicate the matter. Accordingly, Annexure 25 has emanated. Now, if your lordship looks into Annexure 25, your lordship will find a reference to series of letters that by so and so letter, the case was recommended by the center did not approve, etc., etc. All these things were stated in Annexure 25. And ultimately, they said that granting aid is not a right; it is a it's a privilege. And since the center has not granted, we have not given it. The matter. Then we wrote to them saying that you have referred to certain documents in your order. Kindly provide us with this document. They wrote back to us saying that there are no enclosures to this data. Thereafter, when this matter was taken up for hearing, we brought it to the notice of the court that these are the letters on which they rely upon. They have never brought it on record, even when they had filed a counter affidavit in the court. So, your lordships were pleased to direct them to produce the documents. After taking several adjournments, the documents were allegedly produced on the about 3-4 dates in the past. Now, those documents which have been filed, if your lordship sees, are not complete documents. They are documents of the alleged letters which were given. And what is emanating from these documents is that that the petitioner's institution is being portrayed as a new child care institution before the state government, before the central government.
It is not a new one. It is 1982.
It has been wrongly projected as a new CCI, and as a new CCI, they have not given any new grants. It's a fact that the center has not given any new grants to any new CCI. And as far as the old CCIs are concerned, whatever has been recommended by the state, the center has given them money, and the center has further stated the question of giving more money does not arise because what we had given for the past year remains unutilized in their hands. So that is where we stand today, my lord. Since 2017-18 to 2018, this institution is without any funds. The district judge has written very passionately in his report.
Where is that?
Shoot the bench.
You appear for whom, brother?
Annexure 20.
I am appearing on behalf of Union of Children.
Union of India.
And we have already filed, as per your lordship's direction, we have filed an affidavit, additional affidavit. Saying that earlier the state government has not recommended the name of the institute, but lateral, though it was recommended, but that has been declined by the committee who has approved, the committee which has approved the granting rate. That's why his claim has been declined.
So committee's order you have put in charge, you are not challenging the committee's order?
No, that was never brought to my notice that the committee has not said no. Committee has said approved. I will show to your lordship. Your lordship had posed a question. First of all, let me show that.
That's why I
posted it to
2 PM. There is a nothing.
Let him come at 2 PM. Or can we have it on the 3rd of November?
Yes. Please, I have waited so long.
Most of the I will serve that affidavit also.
Yes,
you have not served the copy of the affidavit also?
Just a day before.
3rd of November, your lordship may fix a time and
call this matter on the 3rd at 2 PM. 2 PM.
Let the state government be served their copy.
You give it to other side also.
So we have received it. We have received the document.
Yes, give one copy of it. Yeah.
Your lordship, instead of 3rd, can it be 6th?
6th of November. Yeah,
at 2 PM.
Item 22.
There was a direction by your lordships on 29th.
Recover
return from the party concerned. That institute, my lord, have called for this case that accused of the mic recorder. I have a loud voice. Yeah, I'm not. My lord have directed on 20th September, order my kindly receive, to allow, directing me to produce how you have received your salary.
So also, my lord,
and also to my land senior's client, copy number 4. Yeah. And a third institution that where she was working. Yes. That was direction through police. You have got that? No, that my lord direction was that should be placed before my lord in a sealed cover. But my lord's office notice, it has not been produced by that institution. Samanta Chandrasekhar Institute of Management and Technology, Similigura in the district of Koraput. Who appears for the institution? That was not here, not party. I have made an allegation that and my lord's order was, I'm just reading out my lord's order, what my lord have directed. The principal, paragraph 4, Principal Samanta Chandrasekhar Institute of Technology Management, Simiriguda, Korapudi, hereby directed to furnish the complete service book of OP number 4 and also state when she was appointed in the said institution and how long she was in service and also the condition of service such as salary, leave, availment of maternity leave, or such other things in a sealed cover addressed to the Registrar General of this court. This was sent to the concerned principal. There is no sealed cover.
The report, my lord, is flag A1.
In the list, cause list, my lord will get it. In the cause list, what they say? Cause list says that report has not received. Whether this order was sent to him, probably it was sent. Otherwise, how the office would do? Registry has given that noting now. Whether it was sent to the concerned principal, sir.
No, my instruction is that you sent.
It was sent.
Yes. And also, the tribunal's direction to produce the records of the tribunal, education tribunal.
Where are the records of? I am filing my document. You have brought entire record. No, my document. I am put the tribunal's record.
But that mistake on our part, my lord, we have issued letter to the director of higher education, my lord, in place of secondary education. Is it wrong?
No. It is send a letter to him and produce those records first, my lord. It put wide order dated 20 September 2025 had stayed as that. Till date, the principal, Samanta Chandrasekhar Institute of Technology and Management, Simiriguda, Koraput, has not produced furnished the required information to the Registrar General. The records reveal that this order was sent to the principal. I feel that there is no response from him. Therefore, next paragraph. Therefore, the principal is hereby directed to be personally present before this court on 11/11/2025 at 11 a.m. and show cause why he should not be arrested and detained for not complying the court order. Registry to send a copy of this order to the said principal by speed post immediately. Along with a copy marked to with Superintendent of Police, Koraput District. So, copy marked to Superintendent of Police, Koraput District. Koraput District. District is also a place. Koraput is a place and district.
Simiriguda is the place and
Koraput is district. Superintendent of Police, Korapura district at Similiguda.
Yes.
Similiguda. No, that is wrong.
District is Korapur.
District Koda is Similiguda.
That institute is my local.
So Korapur district.
Yes, SP Korapur. My lord,
And government to produce record, my lord.
See,
My lord, this is letter to the register. That is Odisha Education
tribunal is to
produce the record.
well, you have to secure that paper.
Yes,
In the meanwhile,
in Appeal 11.
the AC or in AC to secure records, original records from the educational tribunal.
In Appeal number 11 of 18.
In Appeal number 11 of 2018 for perusal of the court.
As well as the appeal, my lord, which the impugn order was passed.
And the appeal number?
Appeal number, my lord. Pursuant to which the impugn order was passed.
If that will be director of higher secondary education.
That office order number.
That's right.
Director higher secondary education.
Call on 1110.
Shall I, my lord, I will submit. I have got the originals.
The next day.
I have also got my original.
I also submitted my
Court have noted that both the sites have kept ready the records which they were asked to produce.
File. Obliged. My lord, interim order to continue.
In the remarks to continue. Yes. Which is that passover matter? Mr. Body is ready. Body was supposed to appear in this matter, na?
The council is there for we are for the interveners. I think that Slum Girls will also be remembering before yesterday. On the Prammer? Slum
Lordship for the petitioner.
I am for the intervener.
Intervener.
That will Lordship Honorable Justice Nagapur personal judgment. That is judgment. The dispute is state government has it.
Is a
After lunch, my locality.
After lunch. There is a division bench. I will have this matter on 13th. 13th November already.
I told
Mr. Swain? You are not. Okay. Call this matter on 13th level. Request of the parties interim order to continue till then. Yeah.
Item 23.
Yes.
But the dispute is relating to date of birth. My date of birth as per the HSC certificate or matriculation certificate is 5/3/1960. And in my service book, that date of birth, that is 5/3/1960, has been recorded. The district education officer, my lord, he issued a so-cause notice to me on 17/11. Sorry, he issued a so-cause notice to me on 1/11/2017 under Annexure 1, saying that.
What is that you are challenged in this?
My lord, I have challenged the rejection order. Your lordship may kindly see the rejection order dated 1/3/2024 under Annexure 9.
Annexure 9.
9. Your lordship may kindly come to paragraph 6, page 33. The findings of the district education officer, because pursuant to the order of this honorable court, the district education officer Keonjhar has taken that decision. Your lordship passed an innocuous order directing the district education officer to take a decision. Paragraph 6. Whereas Sri Abhimanyu Mahanta, the present petitioner, passed annual HSC examination 1978. He received the SLC bearing number such and such dated 27/6/1978. It is surprising to note that the date of birth of Sri Mahanta has been recorded as 5/3/1960. That is in HSC certificate, instead of the actual date of birth, that is 5/3/1956.
in the said SLC issued by the then headmaster Jyotipur High School, Jyotipur, in contravention to the original date of birth recorded in the admission register of Jyotipur High School, Jyotipur. As such, it is clear.
Therefore, he says that you are born on 5/3/56 and not
56 and not 5/3/1960. That is his finding.
What was he? He was employee.
But yes, he was a physical education teacher.
When he entered service?
But he entered into service on 4/9/87.
4/9/87. In his service register, what was the date?
But in the service register, the date of birth, that is 5/3/1960 is there. Your Lordship, may kindly see that.
That was given as on which date?
My Lord, from when he entered into service. My Lord, Your Lordship, may kindly see that.
How dispute arose about the date of birth?
The dispute arose because of the fact that in the admission register of the petitioner in the high school, it was wrongly mentioned as 5/3/1956. Subsequently, his father.
Once again, if it is 1956,
yes,
when will he be completing his 10th standard?
My Lord, he passed 10th standard. 10th certificate I have given. Your Lordship, may kindly see that. That is page 28. He passed HSC examination in 1989. 1989. April 89, he appeared in the examination and passed. Sorry. Sorry, my Lord. That is page 27. Page 27, April 78.
1st March 1978.
79, the date of publication. My Lord, he appeared in the examination in 1st April 1978.
April 1978.
My Lord, on last occasion, Your Lordship posed a question to me, producing the date of birth of his brother and sisters, if any.
Please give them.
My Lord, I have given that affidavit. Your Lordship,
do they match with that?
Yes. Your Lordship, may kindly see that. I have no brother. Only 4 sisters are there.
Elder or younger?
2 are elder and 2 are younger.
When they are born?
Well, Your Lordship, because they have no formal school education, Your Lordship, may kindly turn to page 4, Annexure 10 series.
No, I wanted to know.
Yes.
When he completed his 10th standard, that was in 1978.
1978.
What is the admission age?
Admission age, he took admission in class 8.
No, in your state. The age for admission to first standard is...
Well, first standard is not required. So far as high school is concerned, it starts from class 8.
When I want to know,
yes,
at what age one will be admitted to the school? 5. Then it will be 15 years or 16 years.
That time, my Lord, 11 was there. 10 plus 2 plus 3 pattern was not there. 11
was there.
Yes, so 11 was there.
So it will be 16.
16
years.
Yes.
Maximum 70 years.
Yes, maximum 70.
As on that date, what was the date entered in your service register?
My Lord, that is 5/3/1960. Your Lordship, may kindly see that. Annexure 7.
5/3/1960 is your date of birth.
Yes, page 29.
Where is your service register?
My Lord, that is the first page of the service book. Your Lordship, may kindly see serial number 10. Date of entry in government service 4/9/87. And at the time of entry in government service, well, this is the date of birth as per HSC certificate that has been reflected or recorded. 5/3/1960.
Where is that?
Well, page 29, Annexure 7, the first page of the service book.
4/9/1987 date I am seeing.
Yes, then third column number 3. Date of birth 5/3/1960.
5/3/1960.
1960.
Yes. How the question arose?
Yes, the question arose at the time of taking admission in class 8 in the high school. My date of birth was wrongly recorded as 5/3/1956 by my father. Subsequently, my father approached the headmaster and he corrected it. And there is a provision for correction before HSC examination. After HSC examination, if correction can be made, it can only be made within a period of 3 years as per the statute, that is board's regulations. Beyond 3 years, it cannot be corrected. Even if error has been committed.
In the service register, within what period they should be rectified?
But service so far as service record is concerned, that was not rectified. Well, the first so-called notice was issued to me by the district education officer on 1/11/2017 under Annexure 1.
1/11/2017.
My lord, may kindly come to page 15. The dispute started from this date.
Brother, my lord, how can you change, even assuming that it is not?
And my lord, I have brought Supreme Court judgment. Your lordship may kindly see. So far as HSC certificate is concerned, the evidentiary value of HSC certificate is much more than other
documents.
Yes, other documents. Your lordship may kindly see.
You don't have birth certificate?
Birth certificate, my lord. My lord.
No, you may not have because
in a remote
in the year 1969.
69.
That came in the force in 1969.
Yes. And your lordship may kindly see one paragraph of that judgment, para 2. That is 2000, citation is 2002, 8 SCC, page 351, para 2.
Is it relating to service matter or criminal matter?
No, service matter. Criminal matter, I have brought the decision, but I am not showing that. Para 2. We have heard counsel for the parties and perused the record. It is not disputed that the date of birth recorded in the matriculation examination, as also in the service record, is 19/4/35. It is also not disputed that the respondent joined service on 24/1/1959. If the contention of the respondent is that correct date of birth is 3/2/1937, in that event the respondent could not have been appointed in service in the year 1955, as he was much less than 18 years of age. The date of birth has recorded in the matriculation examination carries a greater evidential value than the evidential value attached to the certificate given by the retired headmaster, showing the date of birth of the respondent.
Why you changed the date of birth?
And another judgment of our own High Court.
He has initially taken admission in his school, and subsequently in the blocked matric ballot, he transferred to another school. And that record he has suppressed ballot.
Which SSLC marks card?
Yes, my lord.
SSLC marks card?
My lord.
SSLC marks card?
Yes, my lord.
There is only one SSLC marks card.
That is one more.
Lordship, I will.
One more is there?
No, only one. Only one.
Lordship, I have to place 18 my lord.
Page 18 of
the writ petition my lord. I have not filed counter my lord. Till then I am basing upon the order of the DEO my lord. I am placing annexure 3 my lord. It will be very clear my lord. Para 2 my lord, I am placing my lord. Whereas on the receipt of allegation from
one public
with regard to overstay of the present petitioner my lord in government service beyond the date of his superannuation due to manipulation of his date of birth in SLC issued from Jyotipur High School. That is the previous high school where
that is the only high school.
Allow me to continue. Issued from Jyotipur High School, Jyotipur, the headmaster of Jyotipur High School, Jyotipur, and headmaster Ukhunda High School, the present where he has passed the matriculation my lord. Ukhunda were requested to by this letter number such and such to furnish the relevant document for verification of genuineness of the date of birth of Abhimanyu Mahanta PT, Kurnikula High School, Kurnikula, whereas the headmaster of Ukhunda High School, Ukhunda, and the headmaster of Jyotipur High School, Jyotipur, produced the relevant document like admission register, cancelled TC, counterfolio of the cancelled TC, and counterfolio of school living certificate for verification of actual date of birth of Sri Abhimanyu Mahanta, son of such and such, of village such and such, District Kenjor. The headmaster of the said school submitted the required document in original as well as Xerox in this office for purpose. Whereas on verification of the above record, it was asserted that Abhimanyu Mahanta, son of such and such, Keonjhar, was a student of Ukhanda High School, Ukhanda, subsequently who took admission in Jyotipur High School, Jyotipur, on the basis of transfer certificate issued from Ukhanda High School, Ukhanda. Whereas as per admission register, the Ukhanda High School, Ukhanda, Abhimanyu Mahanta took admission in the said school on 14/7/1969, bearing admission number such and such, having date of birth, my lord, important, my lord, 5/3/1956. And on 3/6/1976, he took his transfer certificate from Ukhanda High School, Ukhanda, bearing TC number such and such, dated such and such, as a blocked student of class 10. The said TC was received by Abhimanyu Mahanta by himself on 13th June 1976, when he was 20 years old at that time. So he was not a minor on the date of receipt of TC from Ukhanda High School, Ukhanda, as stated by him in his showcase on 30th April 1932.
We'll refer your client to medical examination. Let them examine the bone value.
Yes, I don't.
Matter involves dispute relating to the date of birth and thus incidentally the age of the petitioner, which assumes importance for superannuation. First, petitioner claims that he was born on 5/3/1960, whereas the OP's counterclaim that he was born on
5/3/1956.
5/3/1956. First off, both the sides have produced some material which is not sufficient to arrive at a correct conclusion as to the age of petitioner. First, therefore, it is desirable that the District Medical Board Cuttack to ascertain the correct age of the petitioner by employing the latest medical techniques and submit report in a sealed cover to this court on or before 18/11/2025.
The present age.
Yeah, present age. If it is,
yes,
everything will be known, na?
Yes.
There is a bone marrow test.
Yes.
Yeah, it is just 2 months this side or that side.
Yes.
Registry to send a copy of this order to the district surgeon is there. District
no, that is the state medical board.
District medical board is there.
State medical
board. State medical board, Cuttack.
SCB is the state medical board. So far as District Keonjhar is concerned.
No, let it go before the state medical
objection. I have no
state medical board at Bhubaneswar.
Cuttack. SCB Medical College, Cuttack. You'll also
will go there.
Yes, you'll also fix a date. On that date, he will go.
The petitioner shall be present before the board on 10/11/2025 at 11 a.m.
Yes.
And seek instruction at the hands of the board.
Yes.
Okay.
Fix a date after.
Call this matter on 20th.
Yes.
Okay. That's the best way. Take. Item 24.
Here is the petitioner is challenging the rejection order of his application, rehabilitation application, my lord.
On what ground it is rejected?
The challenge with the ground the applicant has applied for appointment on 24/2013, that is after completion of more than 2 years of date of deceased, it has violated the provision of after 2 years. Page 30.
1 second. So your compassionate appointment application is rejected. When death of employee happened?
Date of employee 22/12/2010, my lord. 22/12/2010, my lord.
22/12/2010.
My lord.
Yes.
Page 31, my lord. Page 31.
That is the death certificate.
No, my lord, the petitioner has approached this principal, my lord.
That is rejected, na?
Earlier, my lord, petitioner applied for 2012. What happened, my lord? Legal hair certificate is necessary. My lord, one Rajana Naik, he was file a claim, my lord, that she is wife of deceased, my lord. She has filed an appeal, my lord. The appeal was rejected on 5/7/2014, my lord.
Now, where is the impugned order? Go to take me to the impugned order, brother.
My lord, impugned order, my lord, page 30, my lord. And page 30.
30?
30, my lord.
Go to 30.
My lord. Relevant portion, Rajana Naik, though had relation with the Dhobi Naik, she is not the legal heir married wife of Dhobi Naik, hence she is not entitled to get the benefits as a legal heir of late Dhobi Naik, as the first and second wife are predeceased Dhobi Naik, the only legal heir who have living as follows, my lord. Thereafter, legal heir certificate issue, my lord.
No, this is the sub-collector's order.
Lordship, impugned order is page 42, my lord.
42, my lord.
42.
Page 11, Annex 11, my lord.
This ground are stated in the application, my lord. Without legal heir, she cannot apply in the court, my lord.
In this case, we have already received the instruction to file.
After Jita Loha judgment, my lord.
That is more than 2 years after death of the employee.
My lord,
What is the period?
My lord, after judgment of the Jita Loha judgment, my lord, the Director of Education Odisha circular the all district education officer and the decision notification saying that last month it was emphasized the application shall not reject to technical grounds, my lord.
Where is the technical ground? If a suit is filed after limitation and if it is dismissed, can it be said that suit is dismissed on technical ground?
My lord, annexure,
entitled to best.
Before my lord, 2 years, my lord, annexure page 13, my lord, annexure 3, the petitioner has applied for to the principal, my lord.
To the principal,
my lord, these are received, my lord. Page 31, my lord.
Who is the appointing authority?
Page 31, 10/9/2011, my lord.
No, who is the appointing authority? Well, the application given to the appointing authority is the correct date for reckoning.
My lord.
Not to XYZ. It should be routed through the principal.
He is stating and the legal heir certificate, my lord. Without legal heir, she cannot apply, my lord.
When
legal heir is necessary, my lord.
When she applied for legal heir certificate.
Not, my lord. My lord, legal heir is the issue, my lord.
No, when he applied, that's very important.
Page 25, my lord. Page 25. She has applied prior to that, my lord. 27/12/2012, my lord. Legal heir certificate issue.
You are not answering the.
She has applied 2011, my lord. After date of
you applied in 2000 after 2 years, more than 2 years. Death happened on 22/12/2010.
My lord.
You applied on which date, brother?
Applied in 2011, my lord. 2011, I applied 2011.
Show that. It cannot be 2011 because your legal heir certificate itself is 27/12/2012.
Because of my lord, because of one Rajana Naik.
Where is your application that you applied in time? These are policy matters. Where how can once we relax that, the rest of the people will come saying that you are relaxed there and you also relax now. It will become 2 years, 3 years, 5 years, and some other person may say after 10 years also. Where is your application? When did you apply for Dixit certificate? Where is your application for a compassionate appointment?
That has been produced.
Who produced that copy?
No.
Call on 1811 petitioner to produce the copy of application for compassionate appointment and also the date on which he had applied for legal heirship certificate. But feeling which petition may be dismissed on that ground itself. Okay.
My lord, MA number, legal certificate number 153/2011. That's why he has applied, my lord. 2011. The certificate miscase number 1558 for 2011. Page 25. 2011 application, my lord. Miscellaneous certificate case number 1558 of 2011, my lord.
You had applied for that?
For that, my lord.
But you applied for appointment on which day? Rehabilitation on which day?
Without legal.
No, without legal heir you could not have applied is one argument.
I have all.
Yes, brother, there are some issues now. Well, unless father dies or husband dies, the children or the widow cannot apply for legal heir certificate. Okay. After death, if they apply, they will take 3 years for issuance of the legal heir certificate. By that time, the period for applying for rehabilitation appointment is over. What should happen to such people? Because your application should be accompanied by a legal heir certificate. Without that, they cannot apply at all. But they will not be able to get the legal heir certificate within 2 years at all. Then virtually you can defeat their right to rehabilitation. Now, as has happened in this case, the time was spent in obtaining the legal heir certificate. Matter went in appeal, there was some dispute, time was spent. Your format says the application should be accompanied by legal heir certificate. Then every application can be defeated and compassionate appointment can be denied to everybody by just telephoning your officer who issues legal heir certificate. Don't decide it for another 6 months. Everything will be over. A larger issue is involved in this case. Where is your objection? What objection you have taken up?
They have received the instruction to file the affidavit.
How much time is being wasted without deciding matters at all? You produce that application and the date on which you had applied for legal heirship certificate. State you will do that? Petitioner to produce, not dismissal, etc.
Have to produce the letters. State has produced.
Any statement of objection you have to do. See, in computing the period of, just I am thinking this way. In computing the period of 2 years, the period spent in obtaining the legal heir certificate should be discounted. Like section 14 of the Limitation Act, where you have taken time to obtain the certified copy of the order, then limitation begins from the date you obtain.
But in that case, when he has obtained the death certificate and when he applied the legal heir certificate, that should be all.
For obtaining death certificate, time is required. For obtaining legal heir certificate, time is required. Matter will be taken in appeal. Appeal will take 5 years, like judges like me. Then by that time, the period for applying for compassionate appointment will be expiring. Where they should go? Therefore, in this matter, you help me. Both of you help me, so that I will lay down. I will say the time taken for death certificate,
that should be
the time taken for the legal heir certificate should be discounted while computing the period of limitation for applying the rehabilitation certificate. That will do justice to everybody.
That's why circular is made.
Circular says what? On technical ground, you should not. But question is, limitation is not technical ground. Technical ground means, suppose they have to put the color photograph, but they have put black and white photograph. The photograph should be 5 mm into 6 mm.
In that matter, there are mentioned applicant are at liberty to submit a new application to additional requirement documents within this was be also have its plans.
Over the limitation.
No, that will not help.
All round is after judgment of the Jita Loha case, my lord. This circular has been placed to all district education officer, my lord.
No, whether the period taken for this one is discounted, that is not mentioned.
All pending application in relation to the government employees prior to the applicants are liberty to submit a new application to additional requirement documents within 12 weeks. The judicial authority.
Well, which is the period? What is the period for applying rehabilitation appointment?
That is 1 year.
2 years. 1 year from the date of death.
Yes.
Some difficulties arise actually. Where is the application format? Which are those rules? Mr. Sven, just help in this matter.
CSRA rules 1990.
Now there are 2025.
That amendment is there. 2020 rules came into force and thereafter amendment was incorporated in 2020.
Just give the book. Just see whether there is a format. And format requires airship certificate.
There is a format.
There is a format.
There is a format.
Whether it requires production of airship certificate.
My lord.
Airship certificate, legal airship certificate.
Yes.
Just looking.
That format is there.
Otherwise, great injustice will be caused.
RA rules. 1990.
There is no such problem.
The format is there. Format is there. The legal air, format is there. The format is there.
Otherwise, very great injustice will happen to the applicants.
Yes.
Under section 14 of the Limitation Act, time spent for doing certain things is excluded.
Yes. The legal air format is there.
Format is there. No, whether that format requires a legal air certificate.
It's a composite. It's a composite form in which a candidate has to apply.
Correct.
There are certain
that form only when the candidate can apply is after he gets that legal air certificate.
That is what I am telling you now. So we can't apply for legal air certificate in advance, saying that my father is going to die on such and such day. Give me legal air certificate. It cannot be.
So that format below it content the chapter 4, chapter IV, which is relating to distress certificate to be granted by the collector of the district.
Collector, that is the below
self-content format.
It is a format. Rehabilitation according.
That is
I'll call this matter afternoon.
That is
I will write. Any court consider this aspect of the matter?
No judgment. No judgment on this aspect.
Otherwise, what happens is he has to obtain death certificate first.
Yes.
Then he has to obtain the legal air certificate.
Yes.
Matter goes in appeal.
Yes.
Saying that he is not legal heir, I am legal heir.
Yes.
That will take some time.
Yes.
By all this is over, it will be 3 years.
Yes.
Then he files the application along with this. In such a case, the time taken for obtainment of the
legal air
certificate, that should be discounted while computing the period of limitation prescribed for making application for compassionate appointment.
Yes.
This is how I want to.
Yes.
Just I am just thinking that way.
Yes.
Kindly bring necessary material. This is on par with section 14 of the Limitation Act.
The rule also prescribes the power of relaxation of this.
Relaxation power is there.
Power to relax is also there.
Yes. That is
Whenever there is a delay in making application,
they can relax.
OCS RA rules, 309 rule contains such a provision which the authority can very well invoke.
No, that is condoning delay. Again, that will be giving much discretion to the authority.
By the government.
That is by the government.
That is by the government.
But the problem is if the application itself prescribes producing of this document and incomplete, that application will be rejected.
Yes.
Then they will suffer the rejection. Therefore, it should not be left to the discretion.
Yes. Rule 911.
Rule 911.
That power of condonation. Power of condonation.
Give that.
Rule 911. Some rule 11.
No, that applies. Yes. Where all compliances are done.
Yes.
Because application has to be complete.
Yes.
But it is filed after delay.
Yes.
There it can do.
Yes, it's.
But I am speaking of the application will not be complete. Because without legal aid certificate, death certificate, it cannot.
There is no such problem.
That I wanted to.
On that aspect also there is no judgment.
Which rule says?
Sub rule 11 of rule 9.
Sub rule
regarding condonation
of rule 9. Notwithstanding the period of limitation prescribed, so it's a years of appointment from the rule with condoned government to concern the administrative department by an order to the effect that applicant had sufficient cause for not submitting the application within such period. Brother, you have said that it is time barred. Where is this considered?
That they have to apply. Have to approach.
He has to make application for condonation of delay. It's not a suit. He is already in difficulty because father is dead, the husband is dead.
Mother is also dead, my lord.
Mother is also dead.
She is alone, my lord. After the marriage of his sister, he is alone, my lord.
Where is the form of application? Name of the applicant, ex-serviceman.
Annexure A.
Annexure A. For details of movable property, if any members so include whether belongs to a CST, the name of the rejection, relationship with the DC, particulars of education, it is so the post applied one. No, there is no requirement of legal
certificate. That is the,
there is no
such requirement.
No, that's there. Yes. List of family members as per the legal year certificate issued by the consent. Yes. They have amended.
Yes.
They have amended. I did that also. Brother, I am laying down the law that way. All right. Allowed on the following ground. Number 1. Rule 10 prescribes. Which is the 1 year period? Where is that?
Rule 7 minutes. Perhaps rule 7.
Which is the section? Which is the rule?
Rule 7.5.
7.5. No, 7 has no 5 at all.
That is amendment rule.
Amendment rules start up to 90 rules, no?
Lordship, it is rejected in the year 2021, madam.
Correct. 21. Therefore, 25 rules are not applicable. 1990 rules are applicable.
Not applicable. 2020
rules. 2020 rules.
20 rules. No, amended rules.
2020 rules are also there.
Yes, yes. After supersession of this.
Rehabilitation of section 7.
No, that's 7. Sub-rule 5 of the rule.
2020 application submitted after 2 years of death of BC government employee shall not be. Rule 7.5.
Rule 7
prescribes a period of 2 years as limitation.
Previously, that is 1 year.
Okay. Under the 2020 rules.
No, 1 year. No, 1 year is legal. Rule 7.3.
No, that is amended.
That has been amended.
Yes.
Rule 9.6 of the 90 rules prescribes that period of 1 year.
No, 7.3 also.
2020. 7.3.
Mr. Swain is pointing out.
7.3.
Shall be received within 1 year from the date of death of the government
service.
5 is application submitted after 2 years.
Yes, madam.
What is the, who mixed these rules? Huh? It says 1 year. And next it makes 2 years. Then 11 gives power to condone the delay. 2020 rules. Rule 7(3) prescribes 1 year. Rule 7(5) prescribes 2 years.
Rule 9 is not there in 2020 rules.
For condonation.
Yes.
Yes, that is not there.
That is not
2020 rules, that is not there.
20 rule have to be seen simultaneously to arrive at a conclusion. Because
Yes.
his case comes under 20 rules.
20 rules.
Going by the date of death. So 20 rule has to be made applicable, and there period is only 2 years for making application. There is no power of condonation.
There is no provision for condonation of delay, unlike in the 1990 rules. However, the application in Form A,
that is also a format under the 2020 rules. Format
specifically requires the airship certificate. A copy of death certificate and details of each of the family members in the format.
But in his case, 1990 rules will be applicable because the date.
2010 is the dead.
Yes.
2010.
10 is the date.
But there is one judgment of the Apex Court which says,
yes.
as on the date the application is considered, what is the rule should be applied?
Yes.
1990. That subsequently 20 rules only.
Yes. But by amending 2020 rules,
Honorable Supreme Court has laid down the law
that as on the date of death, which is the rule.
Yes.
at the time of death. At the time of death. At the time which rule is applicable, that will be governed.
That will govern.
In a matter of Odisha, Honorable Supreme Court has now said that there before the Supreme Court, state has filed an affidavit that we will, wherever we have rejected it, we will allow those candidates to reapply. And their cases will be
by way of amendment
90 rules. 90 rules, not only the 20 rules. Accordingly, they have brought out that amendment. So under that,
it was incorporated in 2025.
That is 2025.
1 September 25.
1997. Rule 10(11) provides for condonation of delay. 2020 rules do not provide for that. There is another set of 2025 amendment rules for the application format requires production of death certificate and heirship certificate first. Therefore, while computing the period of limitation, be it 1 year or 2 years, the period taken for necessary certificates without which application will be incomplete, is liable to be discounted. First off, an argument to the contrary would defeat the very purpose for which the compassionate appointment rules are promulgated. First off, next paragraph. The petitioner father having died, father or husband? Father having died on 22/12/2010. The rule applicable would be 1990 rules, which provide for condonation of delay. But that aspect has not been addressed in the impugned order. First off, next paragraph. Contention of learned ASC that a separate application ought to have been filed for condonation of delay does not impress the court. First off, it is applications made by a member of the family which is in distress because of its breadwinner's death. First off, it is not a suit for filing application for condonation of, it is not a proceeding before the court wherein application for condonation of delay is filed like under Section 5 of the Limitation Act. First, it sounds illogical and therefore cannot be countenanced. In matters like this, it is ideally desirable to make a short prayer in the very application itself for condonation of delay. First off, However, where no such column is found, still the state being the welfare state has to ascertain the circumstances from the material available on record and then to take the decision as to condonation of delay, whether there is a prayer for that or not. First, petition allowed, matter remitted for fresh consideration within 8 weeks.
Pardon me, item number 36, either on 23rd or 30th.
No, this was very difficult for that. We'll have it in the section.
So if there is a F4 date is 20th of Thursday, my lord. Your lordship is taking F1 on Thursdays.
Thursday.
Yes, although whether on 23th.
No, this 26th not possible.
So 30th.
We have posted many matters.
30th.
30th will be on the eve of the.
Not in
The first week of November is on 3rd of November is
First week.
third of November. Over. Third will fall in.
Item number 26. Item number 26. This matter has already been infructuous.
Infructuous. 26.
It has become infructuous.
It is not infructuous.
Committee is over.
Over. 26.
It is not infructuous. Appearing for OP number 5.
My lord, item
It is not infructuous. A particular
petitioner. Who is the petitioner?
I am the
He is saying that.
So if your lordship will say that
It is they who are the petitioners. Dominantly it is.
Yes.
That is right. But so far as
You are only
applicability of a particular rule is under challenge.
You are VP.
Yes.
How can you oppose their submission?
I will oppose on the
For the petitioner submit that petition we disposed of as having become infructuous. First, this submission is opposed by learned counsel appearing for the OP number 5. OP number 5. First, there is no substance in this opposition. First, in view of the above, operating the principle on the doctrine of dominant cases, petition is disposed of on the submission of counsel appearing for the.
My lord, item number 31, my lord. Item number 31, my lord. Beg intervention, my lord. Item number 31. Your lordship judicial order has not been complied with by the opposite party number 1.
Will you permit me to eat
my lord,
lunch and come back?
Because why I am submitting before lordship.
I am submitting. I am hungry. I am also making submission because I am hungry. I will eat my lunch and come back. After lunch I am coming. After lunch, 5 minutes.
Then single judge.
Public. Sorry.
I don't know one. Again with one password just. And my records are coming. One password.
Password.
Item number 2. Record has come.
Yes.
You also kindly look to this judgment. Of course, my Lord Justice Shripad is the party. My Lord Justice MISHRA was not particular. That regulations, copy 6.
What we have held in this?
Single judge, the Honorable Single Judge has said that the regulation is permissible because they have been continuing from 2011 till date without any interruption, and they have been selected through open advertisement and by a selection committee, and same thing. Your Lordship, to the judgment.
Let me place that.
Okay. Oh, sure.
Sir, please serve a copy of the judgment.
Already appeared.
Yes, it is there.
He knows also.
My lord. Lordship, may kindly have a look to the judgment which was passed by the Land and Single Judge of the school. At page 98, your Lordship, may. Instead of going into details, my lord, I'm just page 98 of the writ of appeal. 296, writ of appeal number 296 of 2025. Your Lordship, may kindly come to paragraph 13.2. I'm placing that.
This is for admission today. Reading itself. Is it posted for final?
Fresh admission.
Fresh admission. Fresh admission.
Yes.
It is needless to observe that, my lord, a few lines above my.
Annexure 1.
Annexure 1, page 98.
Judgment, impugned
judgment.
There are 13.2.
13.2, little, 3-4 lines above, my lord, Lordship. As representations are above case of the petitioners are pending consideration, interest of justice would be best met if the opposite party number 1 is directed to consider the same. Hence, the opposite party number 1 is hereby directed to consider the representations of the petitioners in the light of the discussions made above with reference to the decisions rendered by the different courts. Needless to observe that for taking appropriate decision as directed, Shufra, the opposite party number 1 is required to bear in mind that the petitioners have been continuously working as ECG technician with requisite qualification. Their names were recommended for regularization in the service by the authority concerned much prior to publication of the advertisement dated 17/2/2015. It may also be taken note that the opposite party number 1 in connection with order dated 31/10/2014 passed by the Odisha Administrative Tribunal called for a report of detailed fact sheets which is directed to be considered at the time of disposal of representations of the petitioners. 13.3. Since representations of the petitioners has been pending since 2014, the opposite party number 1 is directed to complete the entire exercise as discussed above within a period of 3 months hence. Thereafter, my lord, there are some cases in this paragraph, they have withdrawn that. Subsequently, in view of the submissions by the senior counsel,
13 is not relevant.
Paragraph 13, they have withdrawn the cases.
Yes, because so far as the earlier advertisement,
yes,
they had preferred both the present petition preferred those writ petition.
My lord.
So they
have withdrawn that.
The 2017 advertisement was a subsequent development, which was the subsequent challenge the president.
My lord, exactly, my lord. In view of such submission,
You are aggrieved with this.
Directional both of their representation,
in fact,
which is allegedly pending since 2014.
my lord, in fact, at about 10 p.m. in the night, I got the brief. Entire night I had searched for the judgment, my lord.
Even if you were awake for entire night with my assistance, still you would not have found any ground.
Finally, I found this one.
It is an order to pass order.
Exactly.
Order to pass order on the representation. That's all.
Sir, are you aware about the order dated 24/2/2025 passed by the coordinate bench?
My lord.
While condoning the delay, that paragraph has been quoted in that order. That representation.
I have not seen that.
There are two writ appeals.
Otherwise also. Now the entire parameter in the light of Jago, etc. has been considered by the other, which I was also one of the members, along with Justice Sabu Saab. Now what remains? The only thing is you have to pass order on that representative. So this is an order to pass an order. Nothing beyond that. Though long story is said, perhaps too long a story.
90 pages, I think. So far as, with also kind permission. So far as that portion of that representation consideration, in fact, I have challenged that in the next writ appeal, that is the subject.
You have also challenged?
Yes, that person, because the Honorable Single Judge has come to such a, you have to just have a glance. Kindly come to page 55. What is the finding of the Honorable Single?
That writ appeal is 3071?
Yes, sir. Yes, sir. Yes, sir. Yes, sir. Sir, kindly look to page 55.
The case is just direction to consider.
That will not do it. So that will be regular. Now
you will reject and again you will.
Yes, sir. Yes, sir. Yes, sir. That is exactly. You also kindly come to that. What is the finding of the Honorable Single Judge?
Just we are putting a proposal, sir.
Sir.
Suppose in the light of this, if the consideration takes place.
Sir, that consideration, what you also knows that they will always, this matter also see that when the writ application was filed. The writ application was filed in 2016. And the development has been made. You also have delivered that division bench judgment. In the meantime, Jago, that Shripad and other Shripad and other judgments have also come in the meantime. You also kindly see the findings. If this finding is not disputed, then ultimate conclusion is regularization. Just have a glance. Kindly come to page 55. I'll take only 2-3 minutes. It is gathered, sir. Kindly come to page 55
of the informed judgment?
Yes, sir.
Para 8?
Para 9.
9.
Yes, sir. Discussion analysis.
Page 55?
Yeah, in the first case.
First brief.
First brief.
It is gathered from the pleadings.
It is gathered, yes.
Yes.
It is gathered from the pleadings, arguments, and submission with reference to Odisha Group C, Group D Post Contractual Appointment Rule 2013 as amended by virtue of the Odisha so-and-so amended Rule 2017 that, page 56. 1. The petitioner had been working as ECG technician in cardiology department on contractual basis continuously since 2011. 2. The petitioner had been selected by a process of selection pursuant to the advertisement published on 17/10/2010 in Sambat and Delhi Odia newspaper. Out of 7 candidates selected in the selection process, 4 were given appointment trauma care center and the left out 3 candidates including petitioner were engaged in cardiology department on contractual basis. The report submitted by the administrative officer, SC Medical College, on 6/8/2015, describing background under which the petitioner were engaged to work as ECG technician in cardiology department. Yes. The petitioner were engaged to work as a ECG technician in the cardiology department was in compliance with the direction of the Government of Orissa Health and Family Welfare Department to the Director of Medical Education and Training Orissa with reference to the order dated 31/10/2014 passed by the tribunal passed in way number so-and-so 2014, which was much prior to the advertisement of dated 17/12/2015. Next page. It has been admitted by the opposite parties in the counter affidavit at paragraph 6 that the petitioner have been discharging their duty cardiology department satisfactorily since their joining. It is also admitted by the opposite party in the said paragraph of the counter affidavit that due to unavailability of a sanctioned post, higher authority have been moved time and again. It has been candidly stated by the opposite party in paragraph 6 of the counter affidavit that letters were issued to the government requesting for a creation of the further post of ECG technician for absorption of the petitioner as there is requirement of ECG technician keeping in view of increase in number of patients, in pursuance of which 4 posts of ECG technician are created by the government. Then, sir, kindly come to the conclusion.
How many candidates are here now?
Now we have 2.
4 posts are created?
Yes, sir. Yes, sir.
4 posts are created. Any appointment is made to those?
No, sir. That was first
after that 2017 advertisement was made.
Yes, that was the subject matter. Yes, that's right. 15. Then, sir, kindly come to the conclusion. Yes, sir. Yes. Person to advertisement, selection, qualification, everything.
Only fee taken by the state is their appointment was purely contractual.
Contractual.
Makes no sense.
And they don't have any right.
Made by this
कौन स्वास्थ्य कल्याण समिति my lord, thereafter, my lord, the regular posts were abolished in the year 2013. All the posts, regular recruitment was converted to contractual.
No, posts were abolished.
My lord, all the posts of the state were abolished.
13
Lords may kindly have a look to the resolution which was passed on 17th September 2013 by the GA department.
That is after they were appointed.
Their appointment in contractual by the Swasthya Samiti.
In which year?
In the year 2010 or 11. Something.
11. First one 2010 of that.
My lord.
So as on the date they were engaged, the posts were there.
At that time, the Samiti was given the appointment.
That's all. Who was paying the remuneration to these people?
The Samiti, so NRHM.
That's has it got governmental character?
Yes.
Article 12 entity.
12 entity.
The government sends the fund.
My lord, that's why, my lord, in the year 2013, it speaks, let's make idea.
Already given the rule.
It's a resolution dated 17th September 2013.
CD rule. 13 rule था Rule 5 को तक कुछ तो
नहीं तब ऊपर पूरे
ठीक है जो existing in very okay.
The contractual appointment rules
2015. There the rule says while filling up the vacancies, my lord,
judgment question
the regular post shall be abolished, and contractual post will be created by the finance department. Here there is no regular posts are there. In the last page itself I have marked.
And the judgment which has given to your lordship dealt with also 13 rule in paragraph 4.1.
Unless it is abolished, my lord, regular posts are meant for the contractual appointments, not these posts.
No, where, Mr. G,
my lord,
where services are engaged for long period, even in the absence of posts, we have directed creation of posts.
Yes, my lord.
Here is a case, juxtaposition. I'm just putting them in juxtaposition. Here is a case where there are posts and they have been working, maybe contractual. Every service, see that Tulsi Ram Patel versus Union Office.
Yes.
Every public service begins with contract, graduates to status. We need, therefore, they gained entry to contract would not inure to your benefit. Any service will begin with contract only. Though it attains status in the case of regular recruitment. Now that status they want.
They want because, my lord, for coming to the regular status, my lord, they have to come through a recruitment process altogether.
That argument is available.
Yes.
Even when a person is appointed for 30 years. That argument is available to you. Even when services of a person are continued for 50 years, if he is engaged at 10, because there is no prohibition for child labor.
No, that argument is not available for that.
Therefore, how jurisprudentially you are justifying the reasoning of the learned single judge has recorded a finding. The posts are created on the recommendation. So they have recommended that services of these people are eminently required. But unless you create the posts, we cannot continue them. Please generate the posts. And the posts were generated. And now you say that you don't want to operate. Having generated the posts, you want to go for public recruitment. We have to balance some.
They were given appointment on contractual basis for years together.
Yes. Since 2011.
Whatever.
Maybe. So thereafter on recommendation, posts were created. Now taking a plea that their appointment was purely contractual, they don't have any right to ask for regular absorption.
How far it is sustainable?
Because, my lord, the contractual rule 2013 was in operation when they are.
That was not under this rule.
My lord, that was.
Their appointment was not in terms of the said rule. Because this rule required the permanent absorption after 6 years.
Yes.
That also the government didn't do. They had to approach rush to this court and file petition for their absorption.
Probably I
then
can
only
convince your lordship. Here, my lord, the appointment.
Just after 6 years.
Here is all the post for abolished. That is it. Without abolition, really corresponding.
Corresponding regular posts are retained.
Yes. Regular, yes, my lord.
So it is not abolished.
Will be created. By then that's the rule says.
But their appointment was not in terms of this rule. That was prior to that.
It was in the year 2011.
Yes.
But here the advertisement was made in the year 2015. That is under challenge for your lordship.
That was in the previous writ petitions, which were disposed of as infructuous.
Yes. Because
withdrawn.
Yes.
But the subsequent advertisement made in 2017, pursuant to creation of post, they rightly challenged that because that was meant for them.
By then, my lord, the posts were not there.
Maybe for that the post were created on recommendation of the department.
Yes.
Only to accommodate them for their regular absorption. So it was meant for them to make an open advertisement to fill up those posts created for the petitioners.
Yes.
Was the subject matter challenge in 2017 petition?
Yes. My lord, that is what. That is.
Yes.
Your lordship, kindly look to your lordship's judgment. Your lordship also referred to the 13 rule. Paragraph
13 rule is not.
Yes, sir. Even your lordship said the continuous service or the long period.
No. 13 rule is not here. Admittedly, their appointment were purely contractual.
Yes, sir.
They worked for years together on the same terms and conditions of contractual engagement. Their work was found to be satisfactory. There is a recommendation made by the authority concerned to create posts to accommodate them to be regularized, their service to be regularized. That was created. Still, there was an advertisement inviting applications for this from open market to fill up that post.
In Jago's case, you also knows that everything has been clarified. That the position.
Subsequently, Shripad was also.
People think there. They just so judgment.
Now, parapinum. Made a forum that take a short. That goes with the point.
The rules of the So the state's appeal stands dismissed and your appeal stands allowed. That would be the substance of the judgment to be pronounced by this. ଆପଣ ଏଇ ଗୋଟିଏ ଜଜମେଣ୍ଟ ନା ଆଉ
ଧର୍ମ ଚରମ ସିଂ
Kindly put in a folder.
Yes, sir. Right, sir. Paragraph and
citations with paragraph.
Right.
And copy to be served on
in course of the time. I have brought it.
That will be party intent to the lightning.
Yes.
Item 2. I am the petitioner, my lord. In this case, coordinate has been passed no order. I was not counsel on that case. The counsel for the petitioner praised taking adjournment and can you see the order? No, out of stretch.
None out of proposed.
Should I go? My matter is 15519. They have tagged the matter along with that writ petition.
It is not concerned with that matter.
Yes, a similar matter. There are a list. I have given that there are 22 cases similar.
No, Commissioner, this matter should also have been listed along that batch of cases.
Batch of cases. They have order, the coordinated bench order. I was not there, but this order has been passed in my instruction. Department has given the today morning that this order has been passed. That's why I am just.
Your appeal has become infructuous.
No, my lord. No. It is there, my lord.
It's an old case. That cases have been filed thereafter. Perhaps it has. I have not seen any order. I have no information.
This number is
15519 is
by the coordinate bench. It should be released from the board to be listed before that bench. That is your submission because of this order.
No, I am not submitting. You lordship, I am ready to.
The sole intention of bringing it to the notice of this regarding this order is matter is to be released from the board to be listed before that bench which has passed this order. Yes or no?
This is my no. This is your lordship. Who is my lord?
ଆପଣ ଏଇ ଯୋଉ ଅର୍ଡରଟାରେ ଆପଣ କେସ୍ ନମ୍ବରଟା ଅଛି 15519 ଆପଣ ଯୋଉ କହୁଛନ୍ତି ସେଥିରେ ଯୋଉ 24/9/2025 ଯୋଉ ଅର୍ଡର ହେଇଛି ତେଣୁ ଏଇଟା ଆମେ ରିଲିଜ କରିଦବୁ ସେଇଠି ଲିଷ୍ଟ ହବ ତ ଓଡିଆରେ ବୁଝିବେ ନାଇଁ ହଉ
More information. I am not. No, anyhow, just saying that.
Yeah, but I think this has been specifically.
This bench,
seems to be that.
Noting this is specifically assigned
by the honorable chief.
That's why.
Yes.
Yes. Honorable Sangam Thau and
Honorable Justice
Honorable Shiva Prasad Mishra. He was involved in the Supreme Court.
In this
that
case.
is why the file was for the Honorable Chief Justice.
Then that matter was listed before Honorable Justice Sawa and Justice Mishra. And Justice Mishra was concerned. It was placed before the Honorable Chief Justice. Then it has been filed for Justice Dixit.
That's the old factor.
We can take it.
Since the assignment is by the Honorable Chief Justice, now we have to hear the matter.
Yes, I am ready to argue.
Yes, you are ready.
Yes, I am ready.
Mr. Bose is arguing.
Yes, I am ready.
Kindly see page, Annex 1, page, input order starts from page 28, madam. This is the case. The petitioner challenging the order of the learned cat dated 14/1/2020.
Cats and dogs are also learned.
14/1/2025, wherein page 36, the input order is therefore the action of the respondent rejecting the case of the applicant on the basis of new criteria is illegal and bad in law. Therefore, the respondent added to consider the case of the applicants as per the old criteria of notification dated 13/7/1998 and conduct written examination for the applicants accordingly. It is made clear that in any case, the entire shall be completed within a period of 6 months from the date of receipt of copy of this order. But what is the fact of the case is, my lord? The petition, the response were land users, my lord. In the year 84, 85 and 1993. The issue 93.
They lost the land in what project?
In the issue particular rehabilitation of land outstretched, whose lands were acquired between the rail line, Sambalpur Thatcher rail line.
Laying the railway line.
Railway line for the lands were taken by the railway. 24 November 1987, Railway Board issued a policy and established rules for offering employment to persons displaced by the acquisition of land for railway projects.
Your land displaced person.
Displaced person and annex, sir.
What that policy says?
Policy that one of the family members are get the job.
Be given the employment.
Employment. One of the family members and whose qualifications are.
'87 policy did not prescribe any educational qualification.
Yes, there 98 notification.
Supreme Court judgment.
Supreme Court judgment meaning the annex.
Annex 3.
3. Specifically stated there. In start from 39 page.
Is it very same acquisition?
Same.
The learned cat has interpreted
Even it was made, it was widened.
Yes.
Even though those who are not approached, then also they can approach for getting the relief.
Minor. But in fact, well, in this case, what happened?
Running page 48. We were concerned about the strategy. The reasons which made the rejection of the land of Oshki to not shortlist the statements which have been said that we have indicated for protection which are other than the any education subsequent. Persons have not committed that the way of the use that still be technical to reject the application without the sufficient of the land. The process the policy is formulated in the history of this content with the land acquisition those civil authorities. Very certain the person should be associated to education. If the entire word formed as the with the declaration. Now, in that in this judgment also, Apex Court did not say any qualification, educational qualification.
They did not say any qualification and not as
that class type. Class type repeatedly it has been said. In the Apex Court judgment.
No, earlier it was class 8 as per the 98
Yes.
But subsequently what they did, they made it 10th standard.
That the cross of the
That is the cross.
That is the cross.
Cross at the point is. Honorable Supreme Court has repeatedly said, but it happened, it is related to that particular advertisement. Earlier with that past, related because of the delay, related to this and it went up to High Court, up to Supreme Court. Then what Supreme Court did, Supreme Court already said that give 15 years relaxation, age relaxation, number one. number two said that they have not said to change the criteria. That is why what they have said is said. I can establish it said.
Sir, are you representing the private opposite parties?
I am the applicant before the.
Yes, so you have appeared suo motu in this case?
Yes, I am by caveat I have appeared.
Page 50.
Now that
if
Perhaps give me 2-3 minutes time or 5 minutes time, I can say electoral qualification, educational qualification.
In which para?
Kindly say that answer.
Just this 39 is at running page 46.
Yes. Annexation 3 only earlier also.
Come to running page 46.
Yes.
Second para.
That has been said. The dispute in the present case arose from a process of selection commenced on 31st July 98 through an employment notice of the then Southeastern Railway for recruitment of gangman in Group D post in the engineering department of the Hon'Ble division. The advertisement stipulated that the candidates should have passed the 8 standard besides which age requirements are set out. The advertisement stipulated that the selection procedure would be decided by the additional divisional railway manager.
This 8 standard,
yes, that
was subsequently
standard. And that has been not challenged when they are appear in the examination.
Right. Now, next, kindly see.
After they became unsuccessful, thereafter
they are challenged and they filed a modification MA before the Honorable Supreme Court. That has been dismissed. And others on that, Honorable Supreme Court, you filed a proper court of law. And they have filed a
So in the writ petition annexing those orders passed by the Supreme Court,
yes,
in the MA
order is there.
Application for modification or clarification of order passed by the Supreme Court.
Yes.
Which stood rejected.
I have played my that amendment
to annexed that order to the writ petition.
That is the running page, kindly see page 148.
148. Annex 7.
148.
148 is there.
Yes, I filed there before that is they have also annexed the original application.
Yes. 149.
Yes, 148.
And 149.
Operative person at 149.
Yes.
Permission to
file implement of the.
However, it is clarified that
number showing so.
Should any individual be agreed by the process which are followed, a non-exclusion in the select list, it will be open to them to pursue such remedies other available in law. These are given me really hope to
pursue this remedy as available in the law.
But after that selection process they notified, thereafter when we found this, then I was filed thereafter. So got clarified. Then we approved. Yes, the point was there, particularly the basic qualification, because it's a 98 question. And Supreme Court has repeated in that judgment also that the advertisement when it will apply, they should not have given a changing criteria, new advertisement. But kindly see only one line which I am reading from this Supreme Court judgment below. It says, in the document itself, page 39, it starts from 39 page. Last para, operative portion.
Land is the source of livelihood. You take the land and pay compensation, but that will not be complete justice. Therefore, a stipulation is made that the family of the land losers, one person will get justice. Now, by prescribing a higher educational qualification, if you apply that, that virtually amounts to depriving the family of the benefit which otherwise it would be entitled to. I don't say for a moment that there should not be any qualification, but there was one, age standard. And that standard should govern the proceedings.
What the Supreme Court, Honorable Supreme Court has given in the judgment, they have given the educational qualification as per the advertisement. And 6 months time has been given by the when disposed of the civil appeal number 3, civil appeal number 3030 and 3044 of 2019. They have specifically stated what the Honorable Supreme Court is the findings. Kindly see.
1 second. They have to take the report along with
page 50, my lord.
After his judgment of the Supreme Court.
Page 50.
So, Kanungo, we are not in a hurry.
So, no, the issue is this acquisition took place in 1993. As on that date, 1987 railway policy was in force. Under the railway policy, you were supposed to give employment to a member of the family which has been displaced because of acquisition. In that policy, what was the educational qualification?
The educational qualification, kindly see my additional affidavit.
I'm not seeing anything. I'm asking you.
Only 8, the candidates would have passed minimum 8 standard from secondary school.
Yes. Your standard, those who have got 8 standard as on that day, yes, ma'am. You have to consider those cases. Subsequently, rule is amended, higher educational qualification. You may prescribe MBBS, MD, FRCP, Master of Churi, everything you will prescribe. But the object is not that. Object is rehabilitatory. They have lost land because you want to run the railway. For running railway, road is not sufficient. You have to lay the railway. For that, you need the land. You have taken our land and running your railway on our land. You have paid the compensation history. But condition was, a member of the family should be given an employment in the railway itself. That is one of the compensatory conditions. And as on that date, 87 policy was in existence. Under 87 policy, 1987 policy, we are telling it because you said that. 87 policy, 8 standard was the prescribed qualification. If you go on enhancing the qualification, what is fun in having this compensatory policy? It is better to go for recruitment itself.
What the Supreme Court had said is observed in the judgment, page 50, kindly see, my lord.
Yes.
But very importantly, applicants would be entitled to an age election of 15 years.
Correct.
15 years. The applicants of other land outs, apart from 2,153 land outs reflected in the tabulated chart, shall also be duly considered by the regional manager. However, applicants would be required to fulfill all other restrictions, including education appearing at the written test, minimum age requirements, and medical fitness. The written test shall be held exclusive for the applicants from among the land outs.
What was the
which date?
But that is the silent minor in the judgment.
Therefore, we are telling that silent should be to the benefit of the land loser.
But that is a silent matter. Which notification? That is the only cross.
If it is silent, 2 things go against you. The silence should be in favor of land losers. They are the agreed because the object of the policy is to benefit them.
That's why they have given the age election in 15 years.
No, age
as per the advertisement. What is the advertisement? Thereafter, the 2019 we made an advertisement.
No, this advertisement should be consistent with 1987 policy.
That is not specifically mentioned in the judgment.
No.
Not a single line they have not mentioned in the judgment.
Yes, it has been mentioned that it was 8 standard.
87 is mentioned 8 standard.
8 standard.
19 notification is the 8 standard. But 2010, when he has appeared in the examination, at that time he know the advertisement and appeared in the examination. They are unsuccessful. Thereafter they challenge the advertisement. They are well aware about the advertisement.
They work in the land. They don't work in the campus.
What was the basis to enhance the educational qualification? It was not a recruitment process. It was a process to rehabilitate the land outreach by giving them employment in railway. So why you enhance the educational qualification which was earlier admittedly 8th standard to 10th standard? What is the basis to take such a decision?
In 2008, 98, there is a qualification 8th standard. But the day to day, the persons are qualified. That's why the notification has been come on 9/12/2010. And as per the circular, the minimum qualification of 10th.
Where the circular? Did you read before this?
Yes, madam. We have filed and we have taken that averment before the tribunal.
So it was not taken into consideration while pronouncing the judgment, improved judgment in this case.
No, my lord, they have not taken into consideration.
That was not taken into consideration.
That document has not been taken into consideration.
Such a ground in the petition.
Yes, my lord.
That the impugned order is perverse because that document was not taken into consideration while pronouncing the judgment.
Well, I have taken the ground.
That also, I don't think that it's in ground.
The para 5 of my page 21 of a writ petition. The Honorable Tribunal has failed to appreciate the Honorable Appeals Court in the judgment dated 14/2009 has granted the land outside only one specific election, that is the age elections. Honorable Supreme Court categorically held that the land outside would be required to fulfill all other criteria, including the education qualification.
Including the educational qualification means the educational qualification which is specified in 1987 policy, which was in obtainment when the land was acquired. But otherwise it amounts to saying we will not give education.
Judgment came on 2019, and Honorable Supreme Court has categorically said that 6 months, within 6 months you made an advertisement for the land outside.
Correct.
And that is the specifically education qualification mentioned in the man. Kindly see page 54.
54.
Yes, my lord. 3.1. Can should pose
no, my brother asked on what basis you altered the educational qualification.
But there is
is
yes.
Where is the ground in the writ petition that a particular document was produced before the Second Election Tribunal to demonstrate before it that the educational criteria to hold a Group D post has been enhanced to 10th standard, and that is the cause to revise this recruitment rule for rehabilitation of these land losers. Still, it was not taken into consideration. Where is the ground?
But I have taken my counter, my lord, also before the Honorable my lord.
As in the writ petition.
In the petition, we have obeyed the Honorable Supreme Court.
Counsel, please answer the query made by this court.
Have you taken up the contention that all documents which we had furnished to the tribunal have not been considered, adverted to at all, and therefore this wrong judgment is handed? That is not your case.
Yes, my the imputed document of the past in OA number is cut off, otherwise illegal or arbitrary is liable to be satisfied by the Honorable.
That is omnibus ground.
But we have taken specific ground that the Honorable Appeals, as per the Honorable Appeals Court judgment, we have made an advertisement, and as per the advertisement, the education qualification is 10th standard, and they have appeared in the examination, they have unsuccessful. Thereafter, they challenged 2023. Filed MA, and that MA has been decided by the Honorable Supreme Court.
Advertisement was made when?
2019.
19.
Yes.
And in 2023, they approached.
Judgment.
No, but they are telling them go before the tribunal.
Go before the tribunal. Tribunal has directed
on merits. Judgment.
They have got the job on the land outside. They have qualified.
They are not before us. Those 26 candidates, those who become successful, they are not before this court.
No, man, they are successful, they got the job.
So why we are
How that will advance your case?
But they admit that qualification and they are also land out.
They did it. But question is, we are not interpreting a particular rule in the general recruitment process. This is a very special, compassionate recruitment process. Therefore, while interpreting the clauses, the compassion should animate the interpretation. This is compassionate policy, policy of compassion. Is it not? If policy is compassion, it's founded on compassion, the terms of policy have to be interpreted with compassion only, not with Portia's knife, 1 pound flesh, not even a drop of blood. That will not apply here. In every word of the policy, the human compassion should enter. Then the object of the policy is accomplished, not otherwise. They appeared is true, but let them find the
list of dates. List of dates and events of B.
They appeared, they lost, and then they went to Supreme Court. Supreme Court said, go before the tribunal.
And the tribunal interpret the Hon'Ble Supreme Court judgment, my lord. That is the only. Now, what is the prayer of the OA, my lord? Can you see page 79? They have given that.
Sir, you file your response to the counter.
I've got very few time. I will take few time only on the points related to this. But kindly see now whatever shown that prayer, that eligible word that has been substituted by successful. Yeah, filed a case.
What is that? Where is that prayer made in the way?
Original application, Lord.
Annexer?
The annexer 7, page 61. Actually, the tribunal has already considered that and passed the order. What is the prayer? In that prayer, they have secreted that they have prayed for to declare them as successful, not that eligible. Eligible what has been amended.
Amended.
That is corrected because the order itself says, the impugned order itself says that. Because now, lastly, I will indicate that relating to this case below. Kindly see first the judgment of the Hon'Ble Supreme Court, page 39.
That's all. That's what the Central Administrative Tribunal is at running page 79. Running page 79, Annexer 7.
No, 79 is one. Yes, 79 is the prayer.
79 internal. Yeah, sir, please. The relief sought for.
All the offences will be declared eligible in the different test conduct
But
very tough. The educational qualification.
Not.
They are not.
But specifically, they have not made it.
The eligible word of C, it was corrected to successful and it was already the improved judgment. I corrected it that word was eligible. That was corrected as they may be declared successful because of the grounds which I praised. Why they are declared as successful.
No,
that was clear.
Your the selection was denied to you because you did not possess the requisite qualification. They have a challenge to that prescription of qualification in the way.
That time they have advertised because the basis of the advertisement relating to which the advertisement was there. That is after the judgment was passed by the Honorable Supreme Court. Yes. Supreme Court has not said to change the criteria.
Sir, you didn't challenge that advertisement on the ground the criteria have been changed.
That has been
rather you prefer to apply in terms of the said advertisement that appeared in the exam.
Yes.
Became unsuccessful. After 3 years, yes, you approach the central direction.
No, when they that select list was published related with this, then we approached the Honorable Supreme Court. Supreme Court said they are the challenge relating to this process of selection. They are categorically stated you can challenge the process there. That liberty was granted.
Sir, where is your
you could not come.
Sir, where is your
I could not come.
Sir, where is your application? Move before this Supreme Court which stood rejected.
Yes.
Do you have a copy of that? Have you disclosed this earlier?
No, here this application is not there, but the order is there.
The present petition, they approach the Supreme Court or any other outsider?
No, petitioner and so many other.
Mr. Kanungo, do you have a copy of that IA? What was the prayer before the Supreme Court? Why they approached Supreme Court for modification or clarification of the said order? What was the ambiguity in this order which intended
You can say the order which was passed by the Honorable Supreme Court, which has been attached here, they have said that we have given you liberty if you are agreed by the process. What is the process? Because the advertisement also covers the process, the product that I am telling. Because advertisement after the judgment of the Supreme Court. Therefore,
sir, because observation, including the persons those who are affected, 2,300 some odd, there was also an observation. There any other person who is left out, he can also
he can also apply.
Yes.
It is related to application. I am only pointing my case on the change of criteria which has been initiated at the time of acquisition of land. Whether that notification is prevailing as per the order of the Supreme Court.
But you will challenge that before the Central Legislative Tribunal on that ground. The criteria have been changed.
That is the case before the caterpillar. Where is the case that? That is the case. Kindly see, judgment of reading related. They have already explained that. On that basis, we have been allowed that original application only on that point, only on single point. Without my not querying.
There are umpteen number of judgments of apex court where it has been held.
Once you appear and
yes, once you have appeared and you cannot subsequently turn down and challenge.
That reply, Milord will ask this question. I know. Milord, in that case, my reply is a particular judgment in the particular case in which I have a party, and the judgment was passed that if you are aggrieved, then what is the meaning of that? If I am aggrieved in process of selection, which was adopted by the railway, then that judgment will not be applicable to this case. This precedent will not be applicable in that. But another submission, my submission is, also I am having a letter judgment of the Honorable Supreme Court. There also this has been dealt with. The judgment is here, They have dealt with that even if you are taking part, paper judgment is there. That does not mean that you are accepting all the illegality. That judgment is accepted, but it's not necessary to go to that extent,
So we are asking a small question to you. Number one, were you a party before the Supreme Court in which you sought clarification? Number one. What was the ambiguity in the order of the apex court which you sought for clarification of? Where is your application? Number one. Number two, where is your prayer that the prescription of 10th standard instead of 8th is contrary to law and violative of the policy and the inner voice of the apex court judgment? Where is that ground?
That ground is there. That I will place.
For a moment.
Yes,
for our satisfaction.
Yes, I will
place that here.
Yes, I will place that in my original application. This is the ground taken.
Where is that application?
Yes.
Where is that application?
Kindly see,
please come to
page 61, copy of the original application.
Please come to running page 78, where the grounds for relief with legal provisions already stated in para 4 above. So para 4 is your grounds as before the tribunal.
Yes, sir. In fact, those are the facts, not grounds. No, grounds are there. After facts are written, then grounds are there. No ground. These are the facts. No, I am reading. Facts of the case, para 4, heading. It starts from running page 67. That facts, in that facts of the case are incorporated separately after the facts of the case. Yes. Which paragraph?
Where have you stated one sentence?
Yes, sir, I am
Prescription of 10th standard was unjustified and contrary to their own policy and the apex petition also. You participated in the examination. You lost the examination. Then all of a sudden, some intelligence dawned on you and you went to the jail.
Limitation is 1 year.
1 year. There is 3 years.
3 years. Mr. Kanungo, you please collect that copy of MA which was moved before the Supreme Court. File it in form of an additional letter.
That will
Why they approached the Supreme Court? Who approached and why approached?
I will file that document. I will file that document.
Is the facts.
I have stated that I have combinedly taken the ground.
All right, anyway, that copy, MA copy is required because we want to know whether you were one of the there. Number 2, what was the real clarification we had sought for? Because your CAT application also, OA does not mention about that. They have not acted fairly, reasonably. These grounds are there. Where have you stated, when 1987 policy prescribed the 8th standard and the lands were acquired in 1993, that policy was in obtainment. Therefore, they could not have changed the qualification. With that caveat, you should have entered into the examination hall. Having entered the examination hall, written the examination, lost the examination, you will allow 3 years to lapse like the flow of the river, and one fine day you approach the CAT. How to grant relief to you? Yeah.
Thank you. Here, when I reluctant saying examining. Anyway, what happened in the entire your response to the writ petition? Only student cannot be. I have given second ground. Even before you want, it should be hearing should be concluded today. No. Without that, there is no. No, I am examining that relator question. Please to answer that. Please do the. Anyway, if don't take that risk.
Let him produce those copies personally so that it becomes easy for you also.
All right. I am also trying to get that copy. Yes.
It is already 21st November.
Short date will be like. The document will be. What is the 15 days time?
You want more time?
Yes, ma'am.
2 days date. 21st November will be.
21st November, yes.
କିଛି ବୁଝୁନାହାନ୍ତି ଆପଣ ଏକଡ କ୍ୟାଲେଣ୍ଡର ଆମେ ଦେଖି କହୁଛୁ ପରା
See this calendar, not that calendar.
not 21st October. ହେଲେ ତତ୍ପର ହେବେ ତ କଥା କହିଲା ବେଳେ ସବୁ ଚଞ୍ଚ
Yes.
Item 3.
They should have seen.
When counsel for the party should be. Please granted to learn counsel parties for the. Please granted to be learned counsel petitioner to file documents for additional affidavit. Shouldn't specify what document it should.
Yes, whether the MA which that will be for the apex court.
The miscellaneous application move before the for modification. In SLP number set data, annex 3 is SLP important. Instead of additional affidavit. That will listed on 21st now to be taken out to see. No, there is no interim order. Is it?
There is 25/7/25. It's contempt proceedings are paid there.
No interim order, sir. No interim order.
Your interim order has read by granted till next date of hearing. Section of the branch. Some of this for the form of contempt proceeding. Hanging on the head of the opponents.
That's so much. No, item 3.
Number 3.
No, it's number. There's no space. No space.
Next item.
Yes.
Item 3, my lord. It is for orders today. Even though your lordship has passed an order on 25/7/2025, same interim order was passed, notice was issued, my lord. But
IA has been filed for dispensation filing of certified copies. Another IA for
condonation of
condonation. So there is a delay. Unless delay is condoned, appeal cannot be heard.
My lord, delay.
How many days delay?
231 days delay.
So have you filed your objection to the application for the? You don't want to. You don't have any objection.
Obviously, I will have the objection.
So you should have filed your objection.
Notice
you are also not paying for CP time to file objection. Simply observing what.
Let him serve a copy of that.
A copy has not been served.
No.
You have appeared so moto.
Yes.
But notice was issued. Notice was issued.
Notice was issued.
Give one more copy.
No, one more copy.
I'll get that.
Notice. You should notice.
We can condone delay so that matter will be ripened for hearing itself.
Yes.
Is it not?
Yes.
So on of notice you appeared so moto. 25 तारीख दिन आपण जोन इश्यू नोटिस हला सेना अपियर करिले से दिन कहलेनी कॉपीटा देथाते
तापरे कॉपी देले किंतु से आयर कॉपीटा देना
आयर कॉपी दे दियो हां दे दियो डीटा ये गोटे डिस्पेंसिंग कॉपी न देले डिलेटा लिमिटेशन केम दि काउंट
काउंट होई परियो
हां
आई विल गिव दैट
दे देबे ना हां तथापि डिले कैलकुलेट हेछि
31 days,
60 days.
60 days.
After deduction of 30 days, 230 days.
Before
how do he calculate the delay without certificate copy?
Without certificate copy.
Valid presentation, it was written 8/4/2025. Well, certificate copies also are copies.
I'll give that.
That also the state appellate undertakes to solve copy of the IAs on the London Council for the respondent, private respondent by tomorrow.
By tomorrow.
That will be said on 21st to be taken to objections to the IAs from IFNE be filed in the meeting.
21st.
21st November. So we taken up at 2 p.m. In order to continue.
Item 4.
Subsequently, as per for is granted to the next step, thereafter we didn't extend perhaps by mistake. I say further, interim order dated 25/7/2022 passed in shall continue till the next step. Yes.
Item 4.
Item 4 also there is a limitation, 500 some odd days delay. So unless how it has been listed perhaps by mistake for admission, though it should have been listed under the heading for orders.
I directed to file all the documents. I have filed on affidavit and answer A by A. Plug email.
Plug
email. Plug E. Directed to give me all compliance of all documents.
Point what a date.
So that is plug email.
Plug E. Reply filed by the opposite party. Reply filed by the opposite party. Not flag E, annexure E.
Written note have filed that flag E.
You have filed a reply. Reply filed by the opposite party review file question.
In the second case, madam, the connected case I have filed.
Oh, sir. First case you are.
First case I have filed only reply. Madam, connected case earlier listed and directly filed a compilation that I filed in my connected case, madam.
What a copy it is.
Delay condemnation for which objection I.
And delay condemnation I have also filed there in that case.
You have filed objection?
Yes, yes. Both the cases I filed objection. After filing, I directed to file a compilation of all the documents. That I filed and connected case, madam. Sangamtra Chaudhary case. Next case, review petition 17 of 2024.
File করছি cases review application was allowed because this
annexure 3.
Yes, because this case was disposed.
Annexure 3 was now.
24. This case was disposed of by a division bench, my lord, of this court.
Single bench. That's of review cases were disposed of by
a single bench.
But issue was said.
Yes.
Thereafter, basing on that order, these review applications have been filed.
No. That review application have been filed in response to the order of the Honorable Supreme Court, my lord.
Supreme Court permitted filing of the review application.
Yes. Honorable Supreme Court, my lord.
That I am coming, madam.
The division bench ତମେ କହିବ ନା ମୁଁ କହିବି either or ଯେ କହିବା ଜଣେ କହିବା
ଆପଣ କହିଛନ୍ତି ତାପରେ ସେ କହିବେ
My lord, here, my lord, the review application which was filed 479, first case I am holding.
Yes.
In that case, my lord, review applications were in response to the Honorable Supreme Court, my lord. I have annexed the order of the Honorable Court, my lord.
And which annexure?
Annexure 2.
Yes.
Annexure 2. London Council for the petitioner seeks leave to withdraw this SLP so as to file review petition before the Honorable High Court. Special petition is accordingly dismissed as withdrawn with above liberty. My lord, with this liberty, my lord, we had approached this Honorable Court by filing review applications.
Those batch of review petitions?
My lord, issue is same. Issue is same, my lord. In the batch of review applications were allowed. Subsequently, my lord, in this another writ application which was disposed of
this
by
Annexure 2, SLPC 38703 of 2023 is pertaining to the present case or some other case?
No, some other case.
Ravindra
this,
Pradhan.
pertaining to this case, my lord. This case.
This case?
Yes.
Yes, Ravindra Kumar Pradhan is opposite party to this review application. So state approached the Supreme Court.
Yes.
2011-2023 is the order.
Yes.
And you filed the review when?
Review was filed 20th December 2023.
20th. Then a delay has to be condoned, brother.
Delay, so far as delay is concerned, my lord, what happened? Our case is that this case, this order of the single judge related to an order 2015. But this order where I was lead penal file, that is another order, 2018. By misunderstanding all these documents, the issue may be same, but subsequently on appeals court dismissed all the SLP. Subsequently, where we appear and file counter, all this are dismissed. That I annexed in all the judgments. All these are dismissed and the government giving the benefits thereafter to all the similar persons. Only these one person left out on the plea of the review. And the
why, Mr. G, you are selective?
My lord, let's it may kindly bear with me for some moment. Lord. I was expecting that Mr. Mahanti will
say that.
My lord,
I will ask you this.
There was a scheme, my lord, IEDC, that is Integrated Education for Disabled Children. It was 100% funding by the Government of India. My lord, this scheme was continued till 2009. After 2009, my lord, on the closure of this scheme, these petitioners were terminated from their service. The petitioners, those who are having training qualification as CT and BD, will get the trend scale, and the untrained they will get the untrained scale, and accordingly government decided to absorb them in the regular elementary cadre, my lord. My lord, thereafter, my lord, now they are praying for regularization of their past period, which they were working under a particular scheme from 91 to 2009, my lord. That is not permitted pursuant to Dancing's case. That is not permitted pursuant to our this honorable court's Chandrasekhar Sahu's case. Schematic period, your lordship knows, that cannot be regularized as for their pension, etc., my lord.
But if it is very long?
No, it is not. It is from 91, my lord, only.
No, 1991 to 2009.
Nine. That period is a schematic period.
With regular scale of pay. Am I only concerned?
My lord, that period is a schematic period floated through IEDC, my lord. Integrated Education.
Because of the liberty grant.
Liberty. SLP, there was no delay.
SLP, I don't have that instruction, my lord.
SLP was filed in time.
That I have not noticed.
No, otherwise they would have said delay application.
Yes,
condoned, etc. I have not dismissed as withdrawn. No orders. Yes,
I have not noticed. I have no knowledge about that. Filing when filing and have after school only disposal matter is still admission. We are not noticed. Other than when notice is issued, all the issue dismissed. That I have given all the documents in my connected case, my lord. 50 SLP dismissed, they complied the order. The government also complied the order.
Complied?
Yes, that I have given also in my affidavit. 2019 government directed to comply all the orders. And recent 2024 order SLP dismissed. Even after that recent order I have also annexed. It is in my objection at page number.
No, to consider this contention, we have to condone the delay first. Otherwise, we cannot
delay my lord's discussion. I cannot say my lord. I will sit down the delay my lord's discussion. But the original appeal.
This intra-court
single judge. Can I place the order passed by the single judge, my lord, which was allowed?
Division may dispute all the person and complain SLP.
Review application which was allowed.
This inter-court appeal is filed after broking a long delay of 473 days. First stop, application is supported by affidavit. First stop. Learned Counsel EGA, Mr. G, draws attention of the court to the order of the apex court made in November 2023. The CDA order date wherein the order wherein the said SLP came to, whereby the said SLP came to be rejected, dismissed, with liberty to seek review. First off, the review petition has been filed on which date? Just look into the
28th December 2023.
28th December 2023. First off, it is just within about a month after the dismissal of the SLP. First off, there appear to be some arguable points in the review petition, which can be considered if delay is coming. Non-condonation of delay may prejudice interest of the state. First off, in the above circumstances, having been favored, the delay is controlled.
My submission My submission is that similar matters can already indicate. Similar matters are already been dismissed or after court, government giving the benefits.
No, that is on that contention we can consider only if delay is condoned. Otherwise not, because it goes on merits. That's the reason. Now we have condoned the delay, we'll post this matter and call this matter on 21.
Connected matter also same.
A similar matter, there delay of more than 57 days. 570 days delay. Second connected case. Second connected, that delay of 570 days delay.
They offer him cup of coffee. Otherwise, unconditionally, we will be condoning the delay.
521 days.
Yes.
SLP
after also more than 400. It's more than 2 days delay. After SLP. Yes. Kindly see, madam.
59/2023, whereas the review petition was presented on 6/2024.
Madam. Madam. 6/5/2024.
5/2.
They are mentioned in the 15th February. 15 February.
5/2 रे नोटराइज ହେଇଛି बट ऑफिस पॉइंट आउट पर से 6/2 रे फाइल ହେଇଛି
मैडम
वैलिड पेटर 6/2 यस अब कुछ रहेगा मैं तो आउट अच्छी की
Item 1 more is
Item 5.
मैं प्लीज आइटम 5 आज बड़ा रेडी है
already. We'll speak on 21st and that day you come with
yes 21st
on 20th the request of
on 20th October
21st of November.
No, all the cases.
All the
cases. I am OP number 5. All लिखी देवे ना लिखी देवे तो पचा नहीं
Pass over matter 18.
Yes,
your lordship may pass over matter 18. I am for the petitioner. But the matter was reached the other side, the appearing for the university, prayed for adjourned short pass over. Now this is a matter pertaining to issuance of an original graduation certificate of the petitioner way back in the year 90.
She has completed her graduation. Thereafter, she has been issued provisional certificate, mark sheet, and other certificate issued by the college and university. In subsequent, thereafter, now she is working as Anganwadi worker for the purpose of promotion. Her original graduation certificates were needed, for which she applied to the university in accordance to the procedure. Big recommended by the
certificate.
Yes.
My lord, Mr. Mahapatra will assist your court, lordship, but he is held up in the PL bench, lordship.
No, what is this? Even certificates are not being granted.
My lord, let it come in.
Certificates, my lady is asking. You don't want to give the certificate. No, we'll call this matter tomorrow. Okay, yes, tomorrow.
Your lords, may 22, sir, so 22, because you
22nd.
Yes, 22nd. I am appearing for the college. He's appearing for the college. I am supporting him. Oh, yes.
Good luck. Very best now. Yeah. Yes, sir.
Item 25. May I please?
Yes. What is this matter about?
Lordship, this occasion the petitioner to file this writ petition on 16/2/2025. The Lord on the Tahsildar Puri evicted the petitioner from the Satalawadi Matha. The Matha is situated in the seashore of the sea beach of Puri. That is kindly come to Para 1. I have given the details, Lordship.
What is your prayer?
My prayer is that eviction is wrong.
Therefore, you should be restored.
Restored because the Tahsildar is not shrouded with any power. He has.
What is your right to remain on the land?
Lordship. For that purpose, Lordship kindly comes to page 35. My right.
Who appears for the other?
My right.
Sorry, my lord, I have filed an application for intervention to make party to one interlocutor application I have filed.
Why? How you are concerned with this case?
My lord, Pradip Kumar Sahu, one of the local inhabitant, one of the public spirited person who was the campaigner and for to upgrade the Sri Satal on behalf of the Sri Ati Badi Jagannath in the originally land belonging to the Sri Ati Badi Jagannath Das to raise something because earlier this matter was decided by this honorable
What
court.
do you say for impeding applications?
I have no objection, but his locus is after I have handed over the land, donated the land to the Atibadi Jagannath Das. Now collector has taken it. Now he is questioning. He may argue his point. I have no problem. No
We'll allow that application.
Lordship allow and he may argue right now.
Impeding application support to the affidavit is favored.
With the champion of Atibadi Jagannath Das.
In as much as the
Women champions are working here. Big scam involved in this matter, my lord. Will press before your lordship. Big land scam is continuing.
Lordship kindly come to page 35.
Once you have to allow that, and you have to amend the cost title. You have to make him a party. There is a whole lot of process. Application seeking implement. The process by affidavit is favored. Since the applicant can broadly fit into the expression proper party, if not the necessary party in the light of Vajia Begum versus so and so. First, no prejudice will be caused to the petitioner side if application is allowed, except that the cost title becomes little longer. First off, the implement could serve adjudication of the case in its comprehensive way. First, in the comprehensive way. First, in the above circumstances, application having been favored, petitioner is directed to array the applicant. How many? One.
Opposite part note 7, my lord.
Applicant has OP number 7 to the petition and serve copy of the petition along with all the documents.
I kindly serve.
Is a present in the said Column 22nd, I will call this matter. 2210.
Let's see. 20.
Yeah. Call on it. In the meantime, the necessary amendments to be carried out.
Let's. Item 27.
My plea also.
Yes, sir.
That relating rejection of the regulation of the petitioner by the opposite party number 1 under Annex 10, page 38. Now, Lordship can kindly see the last order dated 3rd September. But in this case, well, I have already received the parage comment, my lord. 3rd went to file.
Well, objection.
3rd September order, your Lordship may kindly see, because the petitioner is working since 92. This is the 4th round of litigation. That's why Lordship was pleased to direct that if counter is not filed within the stipulated time, matter shall be disposed of. Anyway.
Yes. Call this matter in the 3rd week of November.
A short date was
At the request of learned ASC, who wants to file the counter in the meanwhile?
Lordship fix a date. Any date help.
25?
25. Yeah. That's the last chance for us.
That is 2025 matter. Yes.
Item 28.
May I plead, your lordship?
Yes.
There is antedirected regulation, your lordship's own judgment. I have corrected that. And opposite advocate for the opposite party also present. Let them take. Yes, I've seen that. I have also corrected, your lordship. That is annexure and date. It's other university, let take a decision in the light of this judgment.
Correct.
Both.
Item 29. Item 29.
Yes, brother.
The last occasion, Lordship has directed the London State Council to take instruction, my lord.
Have you received the instructions?
In fact, it is not the government matters, it is
CDA matter.
Issue is simple, but it has a far-reaching consequence. The thing is that a person applied for flood. It is way back in the 2000.
In the matter. Are you ready in the matter?
Ready in the sense that it can be solved. I think it cannot be considered for this Hon'Ble Court. Fact means Annex 4, kind of class Annex 4 that will suffice the purpose, it can be deformed. Either in the side or that side.
Annex 4.
Annex 4.
To consider Annex 4.
Yes, no, not Annex 4. Annex 4 will be considered and passed on order. Development authority passed on. Initially, my lords, one Nrsinga Charan Laha applied for the application, given application for allotment.
Allotment of outside
plot. Land. It's a cutter development project in the year 1991. Now, in the meanwhile, all the processes are going on. He has deposited the money, everything has taken care of in his name.
Yes.
Now he wanted that he should be taken, all this should be recorded in the name. The revised name, that is Nirod Baran Laha.
Yeah?
Nirod Baran Laha. He should be taken as a Nirod Baran Laha.
Means
his name, he has changed his name, and as per the Odisha Gazette, my lord, under Annex 2, page 11, his name has been changed. And pursuant to that, my lord, the son of the allotee has requested my learned friend's client to change the names.
That's all.
That's all. And
fact remains, my lord.
And what they have written in the page 14, Lordship may kindly see last paragraph.
30.
Page 14, Annex 4, last paragraph.
Last what paragraph? Last time.
You are therefore requested to get appropriate order from the competent court that
Gazette is there.
Yes, gazetted there.
We don't have any provision here so far law is concerned, changing the name from X to Y banner. Suppose I am considered Mr. Mahapatra, Dhananand Mahapatra.
You can change my name any number of times.
You can change, but that is no problem in that. But fact remains, we got allotment in the name of that Nrsinga Charan Laha.
Yeah.
And all these are there. And
In which document your name should be changed?
My lord,
your application form is in the name of Nusio Chanala. And everything, every document, everything, you have deposited the money. Now you wanted to change it in the name of other name.
Only name to be changed.
Name
Yes.
to change.
But person is not being.
That is exactly matters whether the same person or other person, because during that period we are not insisting photograph and all these things. That is what we require, that you get a declaration from competent civil court. Earlier also another matter, another matter that has come
For another 5 years.
No 5 years, no declaration matter. They have to file a suit against the city. No objection from the side of the city.
No, who is disputing his identity now?
No, but the authority says that you have yourself applied in the name of Nusinga Chanala.
Correct.
And you have deposited the money. You in the meantime, one Nusinga Chanala has been allotted that plot.
Now we will. You bring two persons who can identify.
Yes.
may I clear it, my lord?
Yes.
My learned
That will suffice.
My learned senior has submitted. May I clarify it, my lord?
This clarification. The similar matters.
It needs a clarification. It needs a clarification, my lord. My lord, Nussinga Charana Laha is the father of the present petitioner. He was allotted with a land, and after allotment, he changed his name from Nussinga Charana Laha to Nirod Laha, which was published in the Orissa Gazette. And after his death, the present petitioner, who is the son of Nussinga Charana Laha, wants to incorporate the name of his deceased father as Nirod Laha in place of Nussinga Charana Laha. And accordingly, he has submitted one application before my learned senior's client, and they have replied.
In which documents name to be changed?
In their record.
What all those records?
The land records. They are staying in the house. The land building has been constructed over the top.
I think my learned friend stated something, that is the position, but I don't dispute. So far as that allotment is concerned, it was in the name of Nussinga Charana Laha.
Correct. But that name he changed it.
Application.
He got it gazetted.
Yes.
That he has done it subsequent after 10 to 15 years.
Correct.
But fact remains, this authority, this is not one case, many of the cases of this nature. Thing is that now they say that insofar original allotment application what he has given, basing upon which the provisional allotment and final allotment was made, basing upon which possession letter was handed over. Kind of a back to possession handing over letter. My learned friend is closely.
In that letter also name to be changed. In possession letter also name to be changed. It cannot be.
It doesn't require to be changed.
What we can say is, in all further correspondence, it can be changed.
Yes, that will suffice.
As on the date, the names were entered in the records. They will remain intact because they are records.
My lord.
We can't change them.
My lord. For further correspondence,
further correspondence, we can direct.
Yes,
Lordship, that person should be treated, X to be treated
as
with the changed name.
My lord. That direction, Lordship.
Nussinga Charana Laha, my lords. He is no more now.
Yes.
Now his children are that man kind of class to page 10, page 9 and 10.
But when he was alive, he himself had changed the name.
Yes.
He has done it or not, man. There he has not informed to authority, man.
No, there is a gazette now.
So they say that there is a gazette notification. I cannot dispute that also because that he referred to that.
Gazette is a notice to the
I can dispute that, man. That is that they have given it. That was done.
Are there any rules relating to change of name?
But there is no such.
There is no such.
No rule.
No rule.
They are saying that you go and get it done.
Somebody can adopt some name, else when name, that is a completely different thing. But here in this case, record of right concerning the property.
No, in which document you need a change, that you have to specify to me.
Then I have to.
If you want the name to be changed in name.
Now, because of fact, that the lease deed will be executed in the name of.
Nussinga for the
The lease deed is there in the name of Nussinga Charana Laha.
That remains intact.
That remains intact.
Then the question is that if that will be so,
then which document to be changed? If it is already executed.
Yes. For any future correspondence from the CDA.
Future correspondence by what was the necessity of any further future correspondence? If lease deed has been executed, then that this has gone to the Nussinga Charana Laha.
Anyway, you have said, you prove your now there is a gazette notification. Hereafter, the petitioner's father will be known as so and so. By which you declare that. Petitioner's short prayer is in the following text.
The name of his father should be changed.
Has already been changed.
With the alert.
First, counsel for the petitioner submits that petitioner's father's name was changed during his lifetime itself, and to that effect, a gazette notification has also been published, dated on
24th May 2023.
24 May 2023. Father passed away on?
Passed away on, my lord, 18/10/2023. Date of death.
18/10/2023.
Page 12. Death certificate.
Therefore, in all further correspondence, the changed name of the petitioner's father should be incorporated. First. Next paragraph. One more sentence. Despite representation, this having not been done, interference of the court is warranted, argues the counsel for petitioner. Next paragraph. Learned senior advocate appearing for the OP number?
Cutter Development Authority, OP number 1.
Answering OP number 1 opposes the petition, contending that change of name is not that simple, in as much as it will have enormous consequences. In all the records, the earlier name having appeared, the same cannot be at once changed only based on the gazette notification in question.
That also he was the original allotee.
First, he also tells that the original allotment was made in the original name prior to reinstatement.
It also has been executed in his name.
And that even conveyance also has been executed with the same name. First up. Lastly, he submits that no purpose would be served just by changing the name of petitioner's father either. First, next, having heard the counsel for the parties and having perused the Christian papers, this court is inclined to grant limited indulgence in the matter, inasmuch as there is no law which interdicts any individual from changing the name, changing his name. Semicolon. There is abundant material to vouch the claim that petitioner's father had changed his name from Nrsimha Charana Laha to
Nirod
Baran Laha. Why the gazette notification dated
24th May 2023.
24 May 2023. A copy whereof avails at Annexure 2. First up. It has been a long settled position of law that the gazette publication is a notice at large. And therefore, it should be a notice to the OPs as well. There being no rivals. No rivals. Next paragraph. Learned senior counsel appearing for the OP number 1 is to some extent justified in contending that whatever records such as registered instruments, etc., would remain in the name of the person to whom in the original name of the person. However, the correspondence hereafter shall be done, showing petitioners, the name or changed name of petitioner's father. First, with this proposal, counsel for the petitioner is agreeable. First, next paragraph. In the above circumstances and with the above observations, petition is disposed.
Lordship, 31 is a very urgent matter. I was 31.
31, urgent matter.
Urgent, Lordship, you can have taken up. Lordship, any.
On 22nd, we 22nd we take.
Lordship, item number 31.
I have filed an application for intervention. 31. My lord, appointment process is challenged. I am the appointed person. So I have filed an application to make.
Lordship, despite your Lordship's order, because why are you making it an urgent Lordship? My lord, despite Lordship's order not to give the appointment, and they made it Lordship. That's why Lordship very urgent Lordship. That's on 22nd, third, it can be Lordship.
In that case, I may opposite point number 3. I may be added as a party.
Yes, I have no objection if you will argue Lordship.
You can argue the matter.
Lordship, no.
Now you are holding an appointment order contrary to the order of the court.
Lordship.
No.
Yes, Lordship.
Sorry, madam. That you are opposite point number 3, madam. On the day when the order was passed, madam, by the time she has already been appointed.
Lordship, he made it. No, Lordship, he made a statement, Lordship.
This is the communication.
That is completed.
Anyway, that's next date we'll hear.
Yes, Lordship.
Can take it up next week.
Lordship,
23rd.
We are the petitioner in 25.
Lordship, item number 30 is urgent matter. The petitioner is not receiving salary for the past 3 months. It's a very urgent matter. Lordship was directed to be listed it today, but unfortunately, maybe this matter 23rd.
Number 34.
30. On 23rd.
34, my lord, somebody has made a mention. If it week after.
Lordship has already had the matter
Substantially hard. My lord has disposed of the review petition.
This my review petition is not met. Now other cases for other players
all matter
become I have education to argue the case. But next week, because we are having 2 to 3 days holidays, so just week after, so that we can
We are praying that it would have. We are praying for Thursday only. We are praying for Thursday.
or tomorrow, your lordship.
Tomorrow, Thursday. On Thursday.
I'm sorry.
Thursday.
fraud within LN,
No, your
5% I show from record. One is serving in another institution given granted. 2 are minor on the date of appointment have been approved. One has not having the qualification to be appointed lecturer. He has been paid. Now they are claiming the case because some inquiry report by the director given them a clean sheet. Then this fraud cannot be umbrella.
Your lordship has already had the matter and all these issues are before your lordship, and after hearing all these issues, your lordship has already dismissed the review petition.
That is on the ground that it is not
Your lordship.
They are excited that is the 30th. We can have it on 30. How many cases are there?
5 cases. Every individual case is an independent entity.
On 30th.
Last 31 implement to continue. 31.
If you want to continue till next date, waiting. Call this matter.
Your lordship.
Now, one is a holiday here.
November.
November 1st is not holiday.
No.
Sir, your lordship may call.
We'll have it on November 1st.
6th of November.
What is the holiday?
Thursday, 6th of November, Lord.
6th of no.
Item number 41.
Already for 6th of November. 30th of
My lord, item number 41. Only the last week, my lord.
41.
41.
Urgency.
Urgent, my lord. Next.
Better. On Thursday, you put it not in the month of November.
My lord, item number 31, interim order be continued.
Interim order to continue. Wherever interim order stands, all right, 31.
31 mentioned record.
31 interim order will continue.
Yes, I get.